The following program does not have a normal intro because I was really too busy smoothing other things over to get it done. So, Ori? Good evening, everybody. Welcome to the following program. I'm your host, Joe Neerman, aka Good Lawgic. Tonight, a special event, a discussion, a debate, a drawing of pistols with the other side, the evil, heinous, must be slayed Pisco. No, I don't really look at him that way. I just look at him as thoroughly ignorant on anything that actually really matters. So, but that being said, I welcome you back to the show.
How you doing, Joe?
I'm good. How are you?
It's a festive time.
I like the hat.
Yeah, I'm a big believer in the holidays.
Are you?
And yes, 100%. So,
wow, you must be in the. You must like be throwing all the parties attended by 7 lefties, all the religious holidays.
No, it's about family, Joe. It's about family. And so I've been chilling with the fam for a lot of this.
Do they lean politically the way you do?
I would say it's odd. I think that yes, largely.
Where are you from, by the way? Where are you from?
My family is originally from Peru, hence the name Pisco. Pisco is a Peruvian liquor that, for those of you who have like any familiarity with Pisco sours, it's a famous drink. But yeah, that's where my family was originally from. They sort of fled Peru in the wake of the Maoist insurrection that was happening then by the Shining Path, and came to the United States, and I was born here.
Mm-hmm. Well, South Americans tend to be more religious than your North America.
It's a very Catholic country. I was baptized, but I'm not religious.
Mm-hmm. Yeah. And I forgot, you told me last time, but I forgot, and someone asked me recently, what type of area of law do you practice?
I'm in litigation. I'm a generalist. I recently have been doing a couple of contract dispute cases, some arbitrations, but my firm really sort of pushes the generalist model, and so I've done some stuff in Delaware. I've done some defamation cases, and I've done some for my pro bono, a lot of immigration.
Are you located in Delaware?
I'm located in New York City.
Oh, okay, cool.
Yep.
Well, it's just you're a stone's throw away. We should get together. I'm just over
100%. Let's next big trial.
I'm just over the Hudson, so
for sure.
Did you go in for any of the big trials in downtown New York?
I didn't, because I sort of started my career right around COVID. A lot of my first couple of years were remote, at least the first formative years, and so I was in the city when I started my practice, but I was often like in my apartment a lot. Recently, I've been doing a lot more in the last like year and a half, 2 years. Been doing more like in-person stuff, but also just was able to get informed on what was going on without actually attending, even though obviously it's more fun to attend.
Okay, well, why don't we just jump right in on the
let's do it.
Topic du jour, which is the Colorado Supreme Court banning Trump from the ballot.
Yes.
Now, you probably are aware of the news today that the Secretary of State said that she will allow him on because an appeal has been filed. It was not filed by Donald Trump. I mean, the formal filing was by the Colorado Republican State Committee or something like that. So,
we knew this was going to happen and it would be stayed. So it's all according to plan.
I didn't expect that it would be stayed because there's a pending decision. So I thought that they would have to bring a TRO to get him on the ballot, rather than the Secretary of State just bending like that. I did not anticipate. I was a little surprised by the news.
The Colorado Supreme Court, and maybe it's just
they did
the order part.
In the order, they did defer and say we're really not grounding this. We're not saying that this is the way things are definitely always going to be. So, and we defer.
Yeah, and to be super technical, the order actually was already stayed. The Colorado Supreme Court said this is stayed until January 5th. And then it won't be stayed unless Trump has already filed appeal to the Supreme Court, in which case the stay will continue. And so the end result of all this is Trump's going to be on the Colorado primary ballot. Like there's no way the Supreme Court's going to be able to hear or dispose of this case, or really, I would even say show their hand before that date. And so the end result is Trump will almost certainly be on the primary ballot, but that was almost always going to be the case.
Okay.
Yeah.
So let's get into the arguments that were made by the Supreme Court of Colorado, which I believe you referred to. I was told, I didn't see it, but someone told me that you referred to their logic as being unassailable.
Yes.
Unassailable. That's
yes.
That's very
strong language.
That's very young lawyer language when you say something is unassailable.
Well, I'm being a little bit colorful for sure. Mm-hmm. You can nitpick on everything. For instance, the court does not come to an all-encompassing definition of a key term, that is insurrection. The court does not define what insurrection is. It just says whatever it is, it includes efforts to stop the peaceful transfer of power via these means. And so you can nitpick and say, well, should they have done that? Should they have decided it? You can nitpick like the structure of it. Obviously, I don't think that the structure, even though it's a very well written opinion, I would have structured it a little bit differently, because I think they group together certain issues that I think should be separated. So there are some things that you can nitpick. And there are certain.
How would you have parsed it differently? Like, what parts did you?
I basically think there's 3 parts to it. I think that there's constitutional threshold questions, enforcement threshold questions, and substance and merits. The constitutional threshold questions are like, is a president an officer of the United States? Is the presidency an office under the United States? Does the president swear an oath to support the Constitution? Is this a political question? Was this enough procedural due process? Are states empowered to enforce Section 3? And is it self-executing? Those are kind of like the big constitutional threshold questions. Okay. The enforcement threshold questions, because again, it doesn't necessarily have to be via a court or via, as you've just seen in the main, I thought that the news you were going to refer to was the main decision to keep them off the main ballot. That just happened just now.
Oh, I missed that. I didn't even know.
Yeah, the Maine Secretary of State, they're the second state now to disqualify Trump from the ballot in Maine. So breaking news for you.
Okay.
But that wasn't done by a court either. And so the second category, I just told you the first category. The second category I would call enforcement threshold questions. These are questions about, does state law even allow for this, right? And that's one of the major, the 2 dissents who are not the constitutional dissent, as a matter of state law, disagree that state law empowers them to answer this question. And the final category are like the substantive meat issues, like what is an insurrection, what does engage mean, and what is the standard for incitement, and did Trump engage by inciting and incite with respect to an insurrection? So that's the kind of structure I would have done on it, but they have their own reasons maybe for why they did it. But that's just like how I analytically see the case.
All right. Now, with respect to any one of these questions, I just want to be clear here that we're on the same page, at least philosophically, about how the law would operate. Mm-hmm. If Trump wins, to your mind, if Trump wins on any of these arguments, whether it's constitutional and applies to him, whether it's about state law being allowed to enforce this, whether it's substantively about what is insurrection is determined in his favor, this wasn't, or that he didn't, incitement is not part of engagement, or that he didn't incite. And if he wins on any one of these, you agree that he would be on the ballot. Is that correct? 100%.
And if he wins on any of these issues, then the courts will not be able to decide, or they'll decide in the opposite way. That Trump is eligible, right? So they could either do one of 2 things. They could say, we don't even have the power to decide it, and then it would be up to Congress to enforce it or to decide on it, which obviously they won't do, or it'll be up to the electors if you think that the electors are the ones who enforce it, or the vice president if you're John Eastman. So there's a powers question. If the court decides they don't have the power to hear it, then I would admit that Trump wins in the court litigation. But they could also decide that Trump wins for either procedural or a bunch of procedural reasons or a bunch of merits reasons, and that would also result in Trump winning. So there are a lot of ways for. That's why I think that the most likely outcome is the Supreme Court reverses. Even though I think that the logic is unassailable, I do think that there are many ways that the Supreme Court can slice up the opinion, can decide that, it wouldn't even necessarily be that hard. They wouldn't even have to create bad precedent to mess with this. They could just say, the incitement standard is a high threshold and you didn't meet it. or they could say engage, you didn't have enough evidence that incitement equals engagement. And so there are many ways that the court can get rid of this and not disqualify Trump. And the petitioners kind of have to win on every single issue. But I think they have, and I think they should.
Which do you think is the most likely, is most susceptible to being knocked down by the Supreme Court?
I think the First Amendment incitement one, because everyone understands Brandenburg to be a very high threshold. And I think that this court is itching to just point to the self-serving statements by Trump peacefully and patriotically, right? They're itching to point to that. They're itching to cite to many cases, even Brandenburg itself, where like revengeance as a term was used and they didn't find incitement. And so I think that it's loosey-goosey enough and strict enough that the First Amendment is probably near the top of the list in terms of what I think the ground is most likely to. I don't think this court would ever say that Section 3 gets rid of some part of the First Amendment. I think that they're going to say Section 3, we should read it to be consistent with the First Amendment, so we're going to apply First Amendment principles. So, and I don't think even anyone is trying to argue that the First Amendment is somehow undone a little bit by Section 3. And so that seems like a very straightforward way for them to apply pre-existing doctrine and just disagree on the facts, even though they should be given deference to the lower courts.
So, okay. I mean, well, one of the issue as to whether or not they count the level of reliance on the January 6th report. Do you think? Where would you classify? Is that constitutional, enforcement, or substantive?
It is partially constitutional to the extent of procedural due process. If your argument is couched in procedural due process terms, you can say reliance on hearsay, even though there's an exception to hearsay in this case.
There is. There could be. If this is deemed to be a fair.
Yeah, but they can't really review the underlying evidentiary question.
And to clarify the issue for my audience who might not be as familiar with this. So the district court allowed in the J6 committee hearing and use that as a really important source for coming to its conclusion that there was an insurrection and that Trump engaged in this insurrection. So that was, which obviously if he didn't engage in insurrection, the whole Section 3 of the 14th Amendment wouldn't apply. So, and there was a big issue as to whether or not it was hearsay or proper for the court to allow it. Now, there is a specific exception to hearsay for most congressional reports, assuming that you can establish a certain level of impartiality. And that was one of the things the district court spent a great deal of her time in her decision, wherein she did say she had the right to rely on it. And she basically came to the conclusion that this was a reliable report, despite the defendants putting forward as much evidence as they could to show that this was a predetermined result before they even started, before the committee even got together. So I was curious as to his thoughts on that. The Colorado Supreme Court gave their blessing to the findings of the district court, as they did anything that was anti-Trump. They had to find, in order to come to the decision they reached, they had to find everything against Trump, as Pisco just admitted. And so to the extent that the district court found against him with respect to the issues regarding insurrection and the admissibility of the J6 report, they supported the district court in that respect as well. We're good?
Yeah, I totally agree that this is an evidentiary issue, which is a matter of state law for their evidence. But the way it could come in as a constitutional issue is, as you're probably aware, and if your audience isn't aware, I'll let you know, the current procedural due process doctrine is a little bit loosey-goosey in the sense of like, well, we're weighing the kind of procedures you were given, we're weighing the interests of the state, and there's a way that you can make an argument that, like, look, we didn't have extensive discovery, we weren't able to subpoena everyone we wanted to subpoena, the petitioners relied primarily, I don't necessarily agree with this, but this is just the argument, the petitioners relied primarily on a hearsay report, which, it fit into this exception, but it was unfair in the global sense of the kinds of things that they were allowed to do and we weren't allowed to rebut. So I can understand that being incorporated into a general due process argument. I don't think it would move the ball that much, and I think that it's largely been decided by the Colorado Supreme Court, though.
All right. Which element here would you be most surprised if the Supreme Court said the Colorado court is wrong?
It's a great question.
Like, this one, I'm positive they're not going to overturn that.
Yeah, if there's any holding that I think is secure, it is that a president is an officer of the United States, and the presidency is an office under the United States, and that the oath to preserve, protect, and defend the Constitution is an oath to support the Constitution. Those issues about applicability to the president, it feels that even this Supreme Court is not going to go there, and they're not going to bite on the kind of secret code arguments that even the Trump lawyers do not seem to forcefully argue for at a lot of points. And I think that they're inclined to take the ordinary usage of the word office, the words of the Federalist Papers and Alexander Hamilton, how it's been described by politicians from time immemorial. And I just think that the concept that we are sovereign, the people are sovereign, and the president serves as in trust for the people in an office, I think there's tons of great textual support for the office being that of the president, and the president being an officer. You know, that officer means nothing if it doesn't include people who hold office. And so just on that kind of very simple, textual, constitutionally and contemporaneously supported point, I think it would be extremely unlikely for the Supreme Court to bite on what the Colorado trial court found in favor of Trump.
Well, I might shock you.
You disagree?
No. I mean, I'll tell you this much. I was kind of in your camp. What I'm going to shock you with is a factual thing, which is which was a strategy that was employed by the Colorado Republican Committee. That the very first argument that they made, they only had made 4 arguments, and one of the arguments they omitted was incitement. They don't talk about whether this was incitement or engage or anything of that nature. They don't address it. They don't bring it up. They don't say it's a reason for appeal. They don't even go to Brandenburg, which shocked me. It probably shocks you, considering
who?
This is the appeal that was filed today.
I think they're leaving it for Trump, probably.
Perhaps, but they don't have to. They could have brought it up.
True, but I think they're probably going to divide and conquer, and they just finished first, probably.
Maybe that's possible.
But go ahead. Sorry, I didn't mean to.
And I agree with you. I'd be shocked. I'd be shocked if Scott Gessler doesn't raise that on behalf.
Oh, it's going to be it's their strongest.
It would be malpractice to leave it out.
Yeah, 100%.
Yeah. I mean, because I agree with you. It's a very, very strong argument. It would be.
I don't think it's strong. I think it's their strongest.
Okay. We'll talk about that. I'm going to talk about that with you. But I'll point out to you the very first argument that they made was fixating on this issue, where they convinced me in these papers that, you know what, that's a pretty fair argument. Because I was debating this with people from my side of the camp a couple of days ago. A couple of days ago, I actually replayed our debate.
It's unfortunate that it was like cut off.
Yeah,
Can you hear me? Yeah, that it was, and then we had other people kind of like butting in a little bit.
Yeah. No, it was. In fact, I didn't even know who was talking. I thought that the other guy talking, Josiah, I literally thought that was Destiny the entire time. So,
no, you're kidding.
No.
Josiah is very partisan. He's very left wing, and Right. Not that I think that's a bad thing necessarily, but he is definitely. I think he's much more partisan left than Destiny is.
Right. Let me get to a couple of super chats here real quick. So let me bring this up first, because he's saying, "What is an insurrection?" I should do this. Let me share a screen so I can actually.
I can see it.
No, I know, but I have to. In order for my audio to play, and I need to share screen. So let me just do that real quick here, and then I'll come back to this. All right. So he says, "What is an insurrection? Should anyone involved supporting Chaz Chop in Seattle be disqualified using the same standards?"
So this is a great question, because there's actually 2 questions here. So the first question is, what is an insurrection? And the second question, even though it doesn't use it, is asking, what would it take to engage in an insurrection? Okay, so you see how they're different. One is like, what is this thing, insurrection, and what would it take to be called engaging in it, right? You can imagine like the Civil War, everyone agrees that was an insurrection and a rebellion, right? But how you can determine whether someone has engaged in it might be different. You might think, well, selling arms is engaging in the insurrection. If you're selling arms directly to the Confederates, that's engaging. Or you could say you have to literally be shooting. So you could have difference of an opinion there. So they're two separate questions. And to answer the kind of Chaz BLM component to it, in terms of insurrection, CHOP, absolutely an insurrection. Okay? If this is not an insurrection, nothing is an insurrection. We're talking about a group of...
Would you agree that it's a more blatant insurrection than January 6th?
Both extremely blatant.
Because I don't know. It's not even close. To me, it's not even close. You're literally throwing out the local authorities and saying we're in charge here. That's an actual insurrection. It doesn't. Yeah. And so as opposed to what could arguably, the right, the MAGA folk would certainly say is, no, we're trying to make sure that our voices are heard here and that they're going to do the right thing and vote in accordance with how the Constitution allows.
Yeah, I hear that there's kind of like a good faith argument there that like they actually thought that they were justified. My response to that is like justification and good faith aren't an excuse to, like a lot of Confederates thought that they were justified. A lot of them thought that they had legal arguments that they had the right to secede.
No, I'm not saying justified that they were moral.
No, I'm not saying that either. I just mean like legally, right. They felt that they were in the right legally. The Confederates, they did. They believed that they had the right to secede, and obviously they were wrong about that. How did we prove they were wrong? Through the war, obviously. But to answer your question, which one is more blatant? I think that they're both, for me, cross the threshold of absolutely blatant. That for me, I see them as equivalently blatant in terms of insurrection or rebellion. They're both so apparent. Like Chaz, think about it. The Whiskey Rebellion was a case where like what were they doing? They were like attacking tax collectors and obstructing the tax right of like the government to collect taxes over whiskey. This is way worse. Chaz, you're like Good Lawgic is saying, kicking out the authorities either by force or threat of force. That is absolutely an insurrection. And if you were involved in that situation on the ground, I think that you were engaging in insurrection. Okay, easy.
But, and I'll steal man your side for you. Let's say after Chaz happens, someone really is happy about it, and they wandered in there and started planting a garden. So perhaps they're not considered engaged in insurrection.
Yeah, yes. So that's the separate question: is what does it mean to engage in, right? Mm-hmm. I think we all agree Chaz insurrection. And I just to do the Black Lives Matter real quick. When Black Lives Matter supporters attacked federal courthouses, absolutely insurrection. Now, where there can be some disagreements is when there's just like opportunistic looting, that's not insurrection, okay? I don't think that any reasonable person can say mere looting by itself without an specific intent related to the stopping of certain government procedures. If the motive was just to make money, right? Let's say if you were going into January 6th with the intention just to steal stuff, right? You just wanted to steal the nice furniture in there. The podium. Right. Like that I don't think would be engaging in, and let's say everyone there was just there to steal for financial purposes. That's not insurrection in my book. However, for the people who were attacking for ideological reasons, because they thought that the racial policies of these places were bad, right? Either the police station or the courthouses, that absolutely is insurrection. And so I would include that. So if Joe Biden is throwing a Molotov cocktail at a federal courthouse, who here can say that is not engaging in an insurrection? The difficulty is the engagement part of it, in my opinion. Like, is setting up a bail fund after the fact to process money and to give money for defenses engaging in that insurrection? No, but let me give you something else. Let's say that Joe Biden promises these people prior to them attacking the courthouse, hey, I'll pay your bail funds if you go attack this place. That would be engagement, right? And if you look at the Colorado Supreme Court's opinion, it shows and tells you that they need a voluntary, intentional act, not just voicing support. It needs to be more than that. And that's why they have to go through all this analysis about Trump's quote-unquote incitement, which you could agree or disagree with.
Steve Gosney is an attorney who's a friend of mine. He's been on the channel many times. He says if federal law enforcement officers encouraged January 6th protesters to break the law, were they engaged in insurrection against President Trump?
If federal officers were encouraging January 6th protesters to break the law, that is, to encourage them to stop.
They're waving them on in.
Yeah.
If they're waving
Hang on a second. You would need to prove the intent there, and for the cases that you're about to refer to, of waving them in, of standing by while they did that, I think the argument is overwhelmingly this was a tactical withdrawal. Tactical. They're not about to have a fist fight with all these people, and so I don't think that the evidence supports federal incitement or federal involvement in motivating or promoting these actions. However, in the hypothetical presented, I do think if people were encouraging federal officers, encouraging individuals to obstruct the counting of the electoral votes, 100% they were engaged in an insurrection, not against President Trump, against the Constitution of the United States.
I agree with you. I agree with that he misspoke there at the end with the President Trump part. Yeah. So, to the extent that Nancy Pelosi helped encourage this insurrection to happen, so is she engaging in insurrection? If she helps encourage the FBI to motivate people to go in there, she, according to some video, that they're actually providing batons and weapons and stuff of that nature. So, to that extent, can we now make the point that she's no longer allowed to serve as a member of the House because she engaged in insurrection by helping incite this quote unquote insurrection?
If you could prove that Nancy Pelosi wanted this insurrection to happen and did things to encourage it, even just intentionally encouraging it, like, and this is where the First Amendment argument might be one way or the other, but I would think a direct call for lawless action would fit. I don't even think you would agree with that. If someone is directly calling for lawless action in an imminent nature, that would fit the Brandenburg standard. If you could prove that, she is disqualified. She engaged in insurrection. The thing is, though, you can't prove that because Pelosi didn't want that, and the facts show that.
Well, which facts do you think show that she did not want it?
I'm sorry. I'm flipping the burdens here. There is no evidence that shows that Nancy Pelosi wanted this to occur.
That you or I have access to. That's true.
Correct.
True.
Yeah.
Okay. So it's an interesting thought. That would be really flipping everything on its head if all of a sudden now they came forward with evidence to show that she was helping this along, and then all.
But don't you agree, guys? Like if this was all a plot, right? If Biden and the feds were plotting this is insurrection. This is engagement. You're absolutely trying to, in your fraudulent efforts, to obstruct a lawful process of the Constitution. How could this not be engagement in an insurrection? And take the other examples. Suppose that Joe Biden is leading a crowd to attack a federal courthouse during BLM. You guys have to agree. If anything is insurrection, that is insurrection. That's engagement.
Do you need to have violence in order to have insurrection?
You need force or threat of force. I think that is clear that that's needed.
Force or threat of force?
I think threat of force suffices. But it can't just be like, when I say threat of force, it would have to be in the vein of true threat, okay? True threat as in not protected speech. Because I do believe that we should read Section 3 to be consistent with the First Amendment. And so in the realm of true threats, that's a legal term of art for those of you who are not necessarily legally inclined or aren't lawyers. If it's a true threat, I think it suffices. The example I'll give is this. Suppose that a bunch of Confederate soldiers come outside of Fort Sumter and say, everybody out of here, we're taking over, and if you don't, we're going to shoot. I think we'd all agree that even though no force was used and they all come out with their guns out, and no force is being used, it's threat of force, okay?
Right. Okay.
It's a true threat, though. It's not going to be as, there needs to be a tangibleness to it.
Would you count threat of abuse of prosecution as being a threat of force?
No, I wouldn't call
criminal prosecution.
Yeah, no, I wouldn't call that a threat of force. I wouldn't call bribery or fraud or extortion or blackmail. I just don't think that those fit under the labels of force or threat of force sufficient for what the framers would have thought insurrection to mean. Let me give you an example. Like, suppose that Jefferson Davis had some compromising information of Lincoln and said, hey, you better let us secede or I'm going to release these documents. Would anyone say that that's an insurrection? I don't think so. But take another situation. Say Jefferson Davis rounds up a bunch of sympathizing Virginians and goes to the White House and points guns and says, listen, Mr. Lincoln, if you don't do what we tell you, we will kill you. I think that's a little different. I think people would say that that's insurrection.
Okay. All right. Let's get a little bit more. I just want to get overall parameters as to where you're coming from. So I think that's helpful. And then let me just get to a couple of super chats, and then I'm gonna get into a few specific issues that we already ran through. So Frankie Boo, member of the following, welcome aboard, Frankie Boo. Damian Blackfire says, Shining Path is why I'm glad we had a far-right junta in Argentina. As brutal as Videla was, he was necessary evil to lay the Marxist subversion. This is Jackals, by the way.
I don't necessarily... listen, the Marxist movements, the leftist populist movements in Latin America are not your friends. I don't agree with them. That said, I don't think that the only solution to that is right-wing authoritarianism. You
should read The Appeal Together. It answers all. I'm going to be going through parts of it with him. There are parts of it that I'm going to just go through with him because I think that some of it's fairly well written, and I think parts of it make arguments that one or two arguments that I hadn't really even addressed here on this show so far. What about actually being convicted of insurrection? Does that matter?
That I think absolutely would matter as a way to prove engagement in insurrection. One way that you can, one of the procedures you can use, not must use, in my opinion. You could disagree, but one procedure that I believe you can use permissively is the criminal process to show disqualification. What the failure, I think, is of people who are arguing against disqualification is saying that that's the only way. Because the Constitution, Section 3 does not, in my opinion, you can disagree, does not state or imply that a criminal process is required. But I do think that if you were convicted for insurrection, you could be disqualified for insurrection.
So you think... So it's just an amorphous yardstick as to where someone qualifies as being ineligible under Section 3.
I don't think it's amorphous. I think the inquiry is always the same thing. The inquiry is, did you engage in insurrection?
It's an amorphous standard, though. It's a completely amorphous standard. I mean, they happen to choose, I think, clear and convincing evidence was the yardstick they used.
Oh, you're saying
they could have used the preponderance of the evidence.
Yeah, I think I think preponderance of evidence is the correct standard, just to be clear. But I agree with you that the Constitution doesn't lay out exactly what the standard of evidence is. Different than like what procedure you can use. You can imagine a criminal procedure requires beyond a reasonable doubt. Okay, but in the context of other parts of the 14th Amendment, we don't require that high of a standard to show other kinds of government violations. So for the Equal Protection Clause, the standard is not show beyond a reasonable doubt an equal protection violation. If that were the case, that's more of a legal question, and what I'm describing is more like a factual analysis and applying to the law. But my opinion is that courts will work it out, and different places might have different standards, but the ultimate question needs to be resolved by the Supreme Court about what's permissible, and yes, I think clear and convincing is plenty.
All right. Well, Wesley asks, do these amendments after the Civil War address what happened to Lincoln's second election when he was moving the ballots in a number of Confederate states? So I'm not sure. Yeah, go ahead.
My response to that is, who decides the presidential election, folks? States do. States are assumed to be the ones who are deciding presidential elections. States do not have to have elections at all. A state could get rid of all of its elections. Presidential elections. Why? Because it's not a direct vote for president. A state could pass a law, and this was what Trump was advocating for, by the way, just assigning their electoral votes to whoever wins the Republican primary. And the Supreme Court has consistently ruled that would be okay, right? One of the methods by which left-wing people are trying to get a popular vote is the compact, and saying, we're just going to decide that we appoint our electors according to whoever wins the popular vote. There is maybe there's some limits once you give the vote to people about who you can discriminate against, that kind of thing. But there's no requirement for states to have a vote for president. And many states, two states, use a proportional voting system, Nebraska and Maine. And so there's no requirement there. And so when the states didn't have Lincoln on his ballot, on their ballots, why are they required to have Lincoln on the ballot, right?
So I'm gonna ask you this. Well, you brought the compact. So I'm gonna ask you: do you think the compact is a good idea?
Yes, I do. I think that in this day and age, even though it made sense to have a lot of state power in the initial years of the founding of the country, we wanted to have buy-in for the new states, and that required guaranteeing to the new states, oftentimes the smaller population states, that they weren't going to be run over. Okay, and so we wanted to encourage buy-in from the small states and from the new states. In that context, I think it makes sense to put the primacy of states at the forefront. But I think we've overcorrected in this day and age. The president really does seem to be a federal office. People consider themselves to be American first and a citizen of their state second. And before, it was flipped. And given those differences in intuitions about what citizen one to which jurisdiction one owes their primary allegiance to, nowadays being the United States, I think it makes sense to have the president be more answerable to the people as opposed to the several states in the kind of weird system that prioritizes small states over large states.
Why have states at all?
Because states still contain fundamental sovereignty, right? Whether Texas has
why should they have fundamental sovereignty?
Because I think it makes sense to have localities have more say in the meat and potatoes issues of citizens on a day-to-day basis for a lot of things, right? So criminal law, you want someone to be responsive close to where you live in that context, right?
Why?
It makes sense. I think it's beautiful as part of the American experiment for trying new things. And there's a feeling, I think, of a direct connection to democracy, which is lacking if it's just unitary. France has a unitary system. And given how America has survived over the years, I think federalism works. I don't disagree with states in the main. I think that we just need to recalibrate the apportionment of federal representation, and also obviously to extend it to the federal territories like Puerto Rico and DC. They should have a say in federal congressional elections in the case of DC, and for presidential and congressional election in the case of like Puerto Rico.
Well, I'll share with you my personal opinion with that whole compact thing. I think that any governor who signs off on that actually should reawaken the right to tar and feather. I think any governor who signs off on that compact, which the compact he was referring to, in case he wasn't sufficient, in case he and or I failed to sufficiently articulate, is a notion that your state electors, irrespective of how the majority of residents of your state vote, that your state electors will be determined by whoever wins the national popular vote. So, when would it kick in? It would only kick in, the only time it would apply, I mean, correct me if I'm mistaken, but the only time it would apply is this: let's say you're in the state of Ohio, and Ohio has signed this compact, and Ohio has chosen a Democratic, the majority of people voted for the Democratic candidate for president, but the Republican candidate won the national vote. Well, in that case, the state of Ohio will say, we don't care what our local citizens of Ohio voted. The national vote favored the Republican. So instead of sending the Democratic electors that our Ohioans want, we're going to send the Republican electors that the national populace voted for. So the only time it would actually kick in is if your state was inconsistent with the national popular vote, correct?
By its terms, it would kick in at all times.
Yeah, but the only time it would be relevant.
The only times it would change the outcome of where the state assigns their electors would be if the state vote was different than the national vote.
Right. So meaning your local residents wanted X, the national residents wanted Y. So even though your state wants X, we're going to go along with Y. That's essentially what you're doing. Now you're a governor, or you're an assemblyman, or you're a member of your state legislature. And what you're essentially saying, if you sign off on this compact, is that what my local populace chooses is meaningless compared to what the national vote is. So if I'm from the state of Ohio, I don't care what Ohioans think. I care as much about what someone from Iowa or California or Hawaii or New York as anyone here from Ohio. That is the exact opposite of leadership. That is the exact opposite of representation. That is actually stabbing your own constituents in the back and saying to them, F you, I don't care about what you want. We're going to do what everyone in the country wants. And that, to me, is the opposite of what your leaders are supposed to be. You're supposed to be representing your interests, not the interests of some folks who live 500 miles, 1,000, 2,000 miles away from you.
I mean, that's the assumption that we disagree on. And that is whether or not for president, the value should be in the place that you say it should be, which is among what your local constituents think and what your state people think. My prior is that for the president, what matters is the national voice. And that isn't what the Constitution says, just to be clear. What I'm proposing would be kind of using the Electoral College against itself. In my opinion, it would be legal to do it because obviously states have almost unilateral authority in how they assign the electors. You're using the system against itself because in a kind of cute way. But obviously the more clean solution is to just pass an amendment to get rid of the Electoral College. But I accept the fact that it's never been done before, and this would be a change in how we run the country, and a change premised on an ideological position that you may disagree with, and you might have good reasons for disagreeing with. I'm not saying that unreasonable people, you have to be unreasonable to disagree with me. I'm just telling you my preference for the presidency is that in its character, it's a national office, that it's most appropriate to elect nationally.
So if on a national office it's most appropriate to elect nationally, why should we have an individual state have the power to say we're not going to have that guy here?
Yeah, that's not the way we do it now, right? And that's not the way the law is currently.
I just threw your own inconsistency in your face.
There's no inconsistency.
Of course there is.
What do you mean?
There is. Because you're basically saying that the way it should be on a presidential level is on a national thing. And I'll tell you something else. That's also what the first argument that was presented as to the distinction as far as any other officer in the United States, in that the distinction is that this is a national choice. They actually come forward and give an interesting deduction, because one of the questions I had when I had these guys on, and I was leaning your way, saying, I don't really love the whole officer argument. I don't think that's really helpful to Trump. He is an officer. I know it's weird the order they put it in there, but there's a lot of times in the Constitution that they refer to officer. It's implying to him. So to say that it's not applying to, I thought it was a weak argument. I did until I read the point. And then the other thing I said when I was arguing with this guy Sean, who's a friend of mine, I have deep respect for, was, give me the logic. What's the philosophy as to why would the president be the only one who could engage in insurrection?
Right, and there's not a really great answer.
And I was like, I can't come up with a great answer, but they did. They came up with a really solid answer that I was like, oh, you know what? I hadn't thought of that.
Wait, can I just stop real quick to address what you just said about the national character and how is that consistent with the state court enforcing Section 3? I think it's 100% consistent in that my aspiration is for this to be an office with a national character and with a national popular vote. But that is, in fact, not our system. Our system runs on 51 independent elections. Okay? They're all different elections. And they elect electors. And that's the way our system is. And that hasn't changed at all. And so I'm enforcing the law as it is, through the mechanisms that have always existed and have not changed once. On the next question you're going to do is about the officer one. That's a separate issue, but I just wanted to make sure that people understood there is no inconsistency with aspirationally trying to make the presidency more national in character, but acknowledging that the current reality is 51 independent elections that have to be run.
Fair enough. I will agree with you. You're basically saying I might hope for this, but currently I might hope for X, but currently it's not X, and since it's currently not X, that's my position that I'm expressing now.
By the way, I do agree that this would be better if there were congressional action here. Like I don't disagree that it's better to have
congressional action.
What's that?
Did you think that there was no congressional action after?
There was at a time. There was a law that further enabled, I would say, Section 3.
Enforcement laws.
Yeah, but it was obviously repealed.
70 years later.
No, wasn't it? Was within a couple decades.
I think it was the 1940s.
No. I think the
I don't know if
Section
it
3
matters whether it was in the 1920s or 1940s.
Oh, I'm sorry. You might be right. What I'm saying is amnesty was provided previously, but that was within a short amount of time.
Yeah, the amnesty was provided in a short amount of time.
You might be right about that. You might be right
They
about
had
that.
the enforcement laws that were put into.
Sure. My position is that's not required, but to be clear, I think it would be a better world if there were congressional action. I just don't read the text of Section 3 to require it.
So, yeah, well, we're going to talk a little bit about that, but let me get to the argument as far as the logic here is presented by why would the president be different? Because this is something philosophically I struggled with, and I think that this is a fair answer. You're probably going to I'm sure you'll disagree with this answer.
I'm sure I will.
But
who knows? I mean, I've been surprised before.
So the Supreme Court of Colorado opined that it would make no sense to put in place an insurrectionist bar for every other federal office, but not for the president or vice president. But there's a key difference. Every senator or representative represents a geographic area where sympathy for insurrection was, at the time of post-Civil War, a real and legitimate concern, right? So think about it. The state of South Carolina, you have to be concerned that they're going to send in some insurrectionists, and what are we going to do? What would we, the federal government, do to stop that? Lower federal officers, meanwhile, are not elected and thus do not face national electoral scrutiny. Only the president and vice president face nationwide electoral accountability. And if an electoral majority of the voters determine that they want a certain individual as chief executive, regardless of alleged or even actual past transgressions, that is their national choice under the Constitution. In short, the president and his role is different in a way that matters.
I think they're just saying it's different, and I don't understand. It's still not getting to the rationale there.
Well,
it's
they
basically
explained
just
earlier.
saying
This is the very end of point one.
Okay.
So they're just explaining why logically the point that they just made for pages about how often they make a distinction between officer and officer United States as written in Section 3 of the 14th Amendment.
But understand the incorrect assumption there that we just talked about. I'm so glad that we brought up the interstate compact on the Electoral College. So the misconception there is that the Constitution requires elections for president. The Constitution does not require it. These are independent elections. Every state assigns electors however they want to do it. And so all the problems of the states and what we're talking about with respect to states are priced in to how we do presidential elections, because states are who decides the electors for president. And so to the extent that you can say...
But your logic, you don't need Section 3 of the 14th Amendment. They could just say, we don't like Trump, we don't want Trump, we're not allowing Trump on our ballot. And forget about if the Section
but
3
we have the Section 3, and we can't ignore it.
Hold on a second. But that doesn't seem to be the logic that's applied by the Colorado Supreme Court. I mean, that's a novel theory you're putting forward here, which is, you don't have to have an election. You do anything the way you want to. You're a state. You're a sovereign power. You can do whatever you want. Nobody on the left has come forward with the claim of, like, look, he's just too terrible a guy. I don't care whether he engaged in insurrection. I don't care about the 14th Amendment. He's too terrible a guy. Why?
No. I'm not saying that.
Why does the Colorado Supreme Court have to go leapfrogging through all these different ways to try and say, and he loses here, and officer does not apply to him, and this is insurrection? They could have just said, Colorado can decide who they want. Boom. That's it. We don't even have to have an election if we don't want to.
Colorado never did that. Colorado never passed a law that said Republicans don't deserve our electoral votes. Colorado never did that action. And so we live in a world in which Colorado, the state, never made the decision that Trump shouldn't be on the ballot.
The thing you're missing with this whole point is that would be a bill of attainder. If you specifically said this person cannot be on the ballot, that would be a bill of attainder.
You could be cute about it. You could say our electors go to the winner of the Democratic primary. What would be unconstitutional about that? Before, there was just a vote remember, back in the day, what happened was the legislatures just passed a law that assigned their electors. That's what Trump was asking for. I think that
would be wholly unconstitutional. If someone put forward a law, and don't tell me you wouldn't be screaming bloody murder. And I'll tell you something, I'd be on your side if the state of Florida came forward and said our electors go to whoever wins the GOP primary. I can guarantee you.
I would be screaming from
you would be screaming like a lunatic.
I would be screaming
because on your side.
No, but it's not unconstitutional. Everyone understands that the first elections were not popular votes. Those were just the legislatures voting on where their electoral votes went. And if that has to be allowed, right? Because that's how the elections were first run. They weren't votes. The first for George Washington were not popular votes.
Right.
And so states do not have to have popular votes. And so if they don't have to have popular votes, what can they have? Well, could they flip a coin? Would that be constitutional? What else criteria would you do it on? Partisan criteria seems it's a political decision. The states can decide. And guess what? Trump was asking for that. When you see him, quote unquote, and I believe it, but I'm just putting quote unquote so your audience knows when I'm maybe editorializing or when there's a dispute. When Trump was quote unquote pressuring state legislators, what was he pressuring them to do? He was pressuring them to pass a law to unassign the electors, among other things. He was pressuring for a lot of reasons, but one of them was unassign it from Biden and assign it to me. And guess what?
Wait, who was he pressuring on that? He was pressuring
state legislators.
State legislatures are that they should basically co-opt.
They should pass a law that just assigns the electors to him. Now, there's a question about once you have started an election for president, can you rescind it and then pass it? So there's some additional legal hurdles here, but in the main, it wouldn't be nothing. There would be nothing wrong legally with the state just voting in their general assembly and saying, unless there was some state constitutional provision, otherwise, there's nothing federally unconstitutional about the state saying, we're passing a law, Donald Trump gets all the electors. That's how it was done before. That must be constitutional under the federal constitution. That's how Washington was elected. Remember, states decide the presidential election. States decide, not even, right? States decide who the electors are who cast a vote for president. No one can disagree with that, right? Like that is just fact of the matter.
I never looked historically. I'm not conceding that because I never looked historically.
No, you don't have to concede it right now, but I'm just that's totally fair of you. You don't have to concede it right now, but I'm telling you folks, and you can look it up. States run presidential elections, okay? There are some federal rules they have to comply with because there's assumed powers for the federal government to regulate in some way. Once states have decided to have elections, they have to do some things, okay? But in the main run of cases, and you can read Bush v. Gore, where this is part of the opinion, they absolutely affirm the state's role in deciding presidential electors.
All right, let's get into the meat and potatoes of the discussion by the Colorado Supreme Court and the issues that were raised there, if you don't mind. All right. So first and foremost, let's get into the whole officer of the United States versus officer, because that is one of the first arguments that they brought up there. And I'll scan quickly through this. And I'm not going to read like line by line here because I don't want to spend an hour and a half just on reading. I want to use your time.
Sure. This is the cert petition.
This is the cert petition. Correct. Okay. From the Colorado GOP. So
your audience is aware, this is a petition, a legal document requesting the Supreme Court of the United States to review for error, for various reasons, the Colorado Supreme Court's decision to disqualify Trump.
Correct.
Excuse me.
Correct. So the first argument they make is that the president is not an officer of the United States covered within disqualification provision of Section 3 of the 14th Amendment, and they say that they cite back to the district court level because on the district court level that is what the court decided, that the reason that she left Trump on the ballot was because she said that this amendment just does not apply to the president based on the language, based on the text of the amendment itself, and that was overturned by the Colorado Supreme Court, which says no, it does apply to the president. And when they say specifically a person is disqualified only if he previously took an oath as member of Congress or as an officer of the United States, as a member of any state legislature, or as an executive or judicial officer of a state. So there's two elements to this, and I want to parse this out very finely, okay?
Three, I would say. But
yeah, you're right. There technically are three. One is, does it apply to someone who engages in insurrection as president? These are the three I would break down.
Yeah.
Meaning that this is the oath that he took. So does it apply? Does it apply in that regard?
In the oath sense.
In the oath sense of it, right?
Yeah.
And then the second element you have is it barring someone from becoming a president? If, let's say, a senator had done it, can a senator now a senator doesn't want to, maybe he'd be barred from being a senator. Maybe if a senator had made the oath, maybe a senator could become president if it's not applying to someone who...
It is really hard to have shorthand for these three things, but I think I have the terminology, and I think the best terminology, frankly, and I know you may disagree with it, is the Ballot and Paulson paper. I think they have the best terminology for these different kinds of things. Okay. So number one is the disqualification triggering positions. That is, what position must you have had subject to a required oath that would make you eligible? That is, an officer of the United States. So that's the disqualification triggering positions. The barred from positions. That is, what offices are you barred from if you are holding a disqualification triggering position? What barred from positions are encompassed in Section 3? And then finally, was there an oath to support the Constitution? So I know that they're mouthfuls, but it's really helpful shorthand to reference disqualification triggering positions and barred from positions. And that is, what position did you need to hold for this to be applicable to you, and what positions are you barred from, assuming Section 3 applies to you?
Right. Good. That's fine. I think that's a fair way to phrase it. And they take issue on all three of them. But what they focus on primarily is the language in the statute, which, as you're aware, it doesn't just say officer; it says officer of the United States. Yes. And they make the argument, the Constitution makes very clear the president is not an officer of the United States; that he's the one who's commissioning. That he's the one who commissions all officers of the United States. That the commission clause states that the president shall commission all the officers of the United States. So if he's commissioning, he's not commissioning himself. So if someone is qualified as an officer, specifically not just officer, but an officer of the United States, that's not an elected position. That's an assigned position. I'm making you chief of staff. I'm making you the Secretary of Defense. These are offices, and the person who fills it is an officer of the United States because they're selected by the president to fill these roles, as opposed to the president who, from a military perspective, he's holding office, and in that sense, he can be referred to as an officer, but he's not qualified as an officer. According to this argument, he's not qualified as an officer of the United States. So,
I think that particular reading, all of that is obviated if you read into that provision whose appointment is not otherwise provided for in Article 2. That is to say, the appointment of the president is provided for, that is, the election of the president is provided for. And so the reference to officer of the United States in that context, it makes sense for it to omit the presidency because his appointment for has special procedures. That is to say, the Electoral College. Other parts of the Constitution undoubtedly refer to when you're talking about the impeachment clause, for example, it disqualifies you potentially from holding any office under the United States. If that did not include the president, then what we're saying is impeachment would not work to disqualify a president from ever holding office as a president again. But everyone concedes that the impeachment clause
definitely applies to the president. No one's arguing that.
Yeah, so it applies to the president, and a potential thing that could happen in the impeachment clause is to disqualify someone from becoming the president. That is an office under the United States.
But does it refer to the impeachment clause? It refers to an officer of the United States or an officer? I'm fairly certain it doesn't, because they say there's only 3 times in the Constitution that it refers to an officer of the United States, and all 3 of them don't apply to the president.
So this is what it is.
The argument that they're made. That's the key, and I think that changes my perspective. The fact that it's not the common phrase, but that it says officer of the United States according to these papers, and I haven't gone through the entire Constitution to see this, but assuming that's correct, if there's only 3 times that it says officer of the United States in that and as a phrase, and that phrase is used here, and it's listed after senator, member of the House, elector, officer of the United States.
Well, it's listed separately for a reason. That is, Congress people are not officers, right? Congress people are members. You're a member, and the
I understand
Constitution.
that, but then when it's listing third, right? It could say officer, senator, right? If it meant president, it could say
it also doesn't specify
member of the House, elector.
It also doesn't specify justice of the Supreme Court of the United States. But you don't seem to deny that a justice is an officer of the United States, do you?
He's an officer of the court. Actually, no, he is the court. No, hold on a second. This is an important distinction.
Yeah.
This is something that came up during the course of the hearing, which I actually live streamed the 5 days of the hearing and the oral arguments.
They're very interesting, yeah.
Yeah, and it really was. You should check it out.
You mean the trial, and you also live streamed the oral arguments in the Supreme Court?
Both. Well, there was closing arguments were made like a week after the hearing, and then there was oral arguments for the Colorado Supreme Court. So I live streamed all of that. It sort of dawned on me that you and I are considered officers of the court, as opposed to the judge, who's referred to as the court. No one calls the judge an officer of the court. They call the judge the court. That is a different term that is standardized in the way we reference the distinction between a judge and a lawyer, or in theory a president.
Well, here's the problem with that reading, right?
Okay.
We just read the appointment clause, which spells out that the president appoints officers of the United States. How can a Supreme Court justice not be an officer of the United States?
He has to be elected.
Who has to be elected?
The Senate has to confirm them. Now, I guess
correct.
A lot of offices are confirmed ultimately by the Senate.
By the Senate, I would say most, or not. I don't even know most. I wouldn't say that. I would say at the very least, the principal officers of the United States are approved by the Senate, and they're not spelled out by their terms. But we all seem to agree that the appointments clause applies to justices. But again, justices are not spelled out. Good.
Yeah, no. So you're saying that the appointment clause references officers of the United States.
Yeah. And so I think that a justice is, by any reading, I mean, I understand that the justice
Supreme Court is different. It could be the Supreme Court is different in that sense, in that they become an officer.
But it's also Article 3, all Article 3 judges, right?
Okay, fine. I'm saying is anyone who's part of the federal judiciary is considered an officer of the United States.
I think that's true.
All of them have to be appointed by the president, right?
Agreed.
So they're all officers of the United States.
But so let me get into it. Is the vice president an officer of the United States?
No, he's not. They actually make an exception.
That has to follow, right? Like it has to be the case that the vice president, if the president is not an officer of the United States, the vice president can't be an officer of the United States.
That's correct. He's not.
Okay.
Under their argument.
But everyone agree. Let's talk about what we agree on first.
Say she's not.
She's not, right? Everyone agrees that the presidency is an office. I don't even think Trump disagrees with that. Presidency is an office. Everybody agrees that a president holds office, okay? I would submit to you that there is no way that an office holder cannot be an officer. Now, you could argue he's not an officer of the United States, he's an officer of the Constitution or something like that. And you could say, okay, he's an officer. But I think we should agree, first and foremost, that the president is an officer. How can an office holder not be an officer? You look at Hamilton in the Federalist Papers, he refers to the president as an officer of the United States. Clearly.
Does he say it says officer or officer
of
the United States?
Officer of the United States. And I think it's actually cited in the I'm sorry. Hang on a second. Just to be clear.
On this issue here, let me just drop this here because
I misinformed you guys, but I just want to
I always drop that horn for $50 super chat. So Chief Justice Roberts says the people do not vote for the officers of the United States. Article 2, Section 2, Clause 2. They instead look to the president to guide the assistants or deputies subject to his superintendents. And that's from the Federalist number 72.
Wait, but I agree that people do not vote for the officers of the United States. When I was referring to election, I was referring to the Electoral College. The presidential electors elect the president. That's what I was referring to as the election.
The electors would theoretically be the people also. I mean, the electors are all chosen by the people.
I don't think they're the people, but
I say they're not obligated to do so. But that is SOP.
Sure, I'm just making clear to Ed 2276 that I'm not saying or implying that officers of the United States are elected by the people. The president is elected by the electors, okay? And the electors are appointed by the states. And the states happen in their grace to have elections for people in their states, okay? But I am not saying or implying that the people have a constitutional role in appointing either the officer of the United States or the president of the United States.
I think you would struggle in saying that they don't have a constitutional role in choosing the electors. And the reason I say that is because even if you don't look to the text.
Oh, I see. Okay.
What I'm saying is, given the history and the way it's been applied unanimously by all 50 states for the last 2 centuries, to say that the people do not choose which electors are ultimately there, which sounds like the most anti-democratic thing that every leftist, and by the way, I can't stand when people refer to America as a democracy, because it's not. It's a
Boomer.
A
republic is a kind of a democracy, bro. I hate this, but go ahead. Yeah,
here's the thing. I mean, you who support the national compact, yeah, sure, you want to have an actual democracy and turn us back into Greece and Rome. And
I know. I want a republic. My version of America is a republic.
No, it's not. No,
yes,
it
is.
No, it's not. You can't tell me you support the national compact and then you want to tell me that your version is a republic.
A popular vote. We vote for a representative. Still, it would still be the president. It's a republic.
A popular vote means that we're going to have a national vote, and that we're no longer that you're basically trivializing states down into the same effective power as a freaking monarchy. That's essentially what
I don't agree.
The national compact is ultimately.
Okay, you can say that, but then even assuming you're right on that, I'm a hypocrite or whatever. Let's just deal with the reality as it is now, which is we have to agree that the Constitution is a constraint on democracy in the main. Everyone agrees, right? It's trying to put limits on democracy. No,
the question is correct, because our founders, in their infinite wisdom, said, hey, we don't want to be a pure democracy like Greece, like Rome, because we see that ultimately ends up being a far worse tyranny.
I agree we are not a pure democracy. We are not a pure democracy.
Which, by the way, and this is something I think you happen to be like head and shoulders against most of the useful idiots on the left. I can recognize that.
I appreciate that. Yeah.
No, what I'm saying is that most of them are all screaming, "We need a pure democracy. We need," which is essentially you're going along with that argument. And to me, it's
you think I'm being shifty and I'm hiding the ball.
I think it's beneath your intellect to actually think that would be a positive thing.
I don't agree with pure democracy. I think it would be horrible.
Well, that's what you're saying should be the president's.
No, I don't. Well, I don't think that's pure democracy. I think pure democracy is voting on like independent policies and not having representatives answerable during elections. It's just having a general mass of people deciding things as a whole, as opposed to having representatives. And I think the president, regardless of whether he's elected by all the people or all the states, is still a representative subject to elections. So that's why I think it's still a republic. But I think it's, again, we don't need to get bogged down here. It's enough to say the Constitution is a limit on at least pure democracy, and certainly on any kind of just regular democracy. It's saying, for example, even if you want to have a ban on all guns, you can't do it. The Second Amendment stops you. Even if you want to establish a religion, you can't do it. The First Amendment stops you. Even if you want to elect a president in a popular vote in where everyone's vote is like equal, that's not how our system works. You can't have it unless you do something sneaky.
Why?
So that's
what do you mean? You think it's positive?
I think it's positive to put that's what a liberal liberal democracy does. Liberal is not meant to imply left wing.
No, I understand.
Liberal and says liberty, right? A liberal democracy puts constraints and says the democracy can decide a lot of things. It can't decide all this.
It's constraints on the government from becoming tyrannical. That's essentially what the goal is.
Yeah, like the French
were make sure that we don't have to live under the tyranny where we're going to have to quarter soldiers, or they're going to be abusing our basic civil rights, or not giving us a right to counsel, or cruel and unusual punishments, or silencing our speech, or oppressing our religions. And these are the different areas that the Bill of Rights are designed to protect us from our own government.
Yeah, I don't disagree with that at all. And all I'm saying is, I know the French Revolution was after the American Revolution, but we see the kinds of problems that happen when liberties and structures of even anti-democratic structures aren't obeyed. The whole point of having a bicameral Congress, I mean, think about that. That is gridlock, isn't it? But gridlock is a positive in many respects. Mm-hmm. Having inaction and having it to be, the same version passed by both houses, needing it to be signed by the president, that is all intended to slow down things.
Yes.
Because we don't want just a purely responsive thing. That's why the Senate, you have 6 years, 6 fucking years. That's why, some of these people have been in office for years and years and years, and their terms aren't going to end for fucking 5 more years. There's a reason for that. It's part of the genius, the Madisonian genius. I do not deny that. I love this country. Now, I would change it a little bit, but I'm just, the only thing I'm saying is that the president is not elected directly by the people. The states decide it. And the states have primacy in allocating electors. And I think that should be,
but the point is
not debatable.
But the point is this, and I'm going to come to the. I still want to keep coming. Certainly to the. I'm going to try and grab certainly the larger super chats, so that I can because those people are definitely trying to intervene in our conversation and get their thoughts, in a timely manner based on what we're discussing. But where was I going with this? I lost my train of thought now.
We were talking about offshore United States. My bad. Sorry, I misinformed the audience.
Now you said something.
Okay.
Yeah.
Oh, I was saying that states have primacy. I was saying that.
Yeah.
I love the Madisonian structure.
Right. I remember. Stop. I remember. So the question that ultimately comes down then is, if you're making it all about the individual sovereignty of the states and the state's powers, so a state can decide whatever they want, how is it that they're reliant on a federal amendment in order to invoke that power? It sounds like what a horse's ass would say. Pardon my French, because it's like, oh, we have the right to do whatever we want, so we have this federal amendment.
I'll tell you why.
We're going to be the first ones to ever interpret it different from everyone else in the country until like a month from now, Maine's going to follow suit, and we're the ones who are going to end up doing that because we have our sovereign state power. It's such a backward perspective.
I don't think it's backward, because I agree that states have a primacy. But just like America in general, and just like the Constitution in general, it's a qualified primacy. And that is the beautiful Article 6 of the Constitution and the Supremacy Clause of the United States, which says that the Constitution and federal laws made pursuant to the Constitution is the supreme law of the land, anything in state law notwithstanding. Okay, so states are they're mandated to follow the Constitution. Everyone must follow the Constitution. And we know from Supreme Court precedent that states are assumed
but you don't need to be reliant on the Constitution to invoke your sovereign power.
I agree that the states that want to get rid of Trump from the ballot, there can be other ways to prevent him from doing that. But they don't want to do that. The states haven't done that. The states are relying, those states that are they're trying this procedure, they're relying on Section 3, and they're not relying on other things, because Section 3, they argue, already disqualifies Trump from the ballot. Now, you could say that argument is self-serving, that it's bullshit, that doesn't stand legal scrutiny. I disagree, but there's nothing inconsistent about emphasizing the state's role in the presidential elections, and then also saying that states are allowed to enforce this federal constitutional provision, because guess what? States enforce federal provisions of law, including constitutional provisions, all the time, and they're assumed to be able to do so.
They also mirror the federal Constitution,
and oftentimes they have state provisions that mirror the Constitution. You're correct, yes.
So, and that's how they tend to do it, rather than passing legislation that's designed to saying, hey, that's
yes and no. I mean, New York does New York have a Second Amendment analog? At least that's been interpreted to be as strong as the Second Amendment in the United States? No, but
New York basically took the Bill of Rights and said, forget about the Second Amendment. The rest of it.
Well, New York doesn't have a choice about the Second Amendment. New York
that's what New York v. Bruin said. So,
guess what? When the Supreme Court speaks with one voice and says, "Hey, New York, you can't pass this state law," New York doesn't get to decide. No, we don't really feel like enforcing the Second Amendment today. They have to, because that is absolutely binding on New York state courts and on New York state officials. I don't care what the mayor of New York City says. I don't care what the governor of New York.
Anyway, they'll
try, and we'll fight in court like we always have. But as case develops, there's limits on what these liberal
I don't know if you
states can do.
I don't know if you have 4 hours to give me tonight, and so like that. And there's a bunch of arguments that we have.
Sure. Go ahead. I'm sorry. You can shut me up at any time.
Yeah, I don't know that. That's definitely not true. Debbie says that's not what he was asking. He was asking them to assign. Talking about what Trump was asking. He was asking them to assign Republican electors prior to the date deadlines while fraud was being investigated. He didn't want to change the laws. That's a false assumption.
So in response to that,
Well, I need to give her a little. I always give her a little. That's for the $20. So.
Nice. So Trump both argued before and after the safe harbor deadlines, but just to be 1 billion% clear, he was asking for the states to not certify the results of the election, and one way for the state legislators to do so, the only thing available to state legislators, drum roll please, is to pass a law. What else can state legislators do with respect to the state certifications? Are they supposed to not pass a law? Well, what other thing could they do? They have to pass a law.
Actually, I don't think that's true. As I recall, I think they were looking for them to hold off on certifying. Certainly, when Giuliani was running around to Georgia and Michigan and all these different states, he wasn't looking for them to pass a law. They
were doing both. They were going to state executive officials
to decertify the results.
They were doing both. They were both trying to pressure state executive officials.
That's not a state statute. That's not a law.
They were trying to get state legislators to do what they could only do, right? Like state legislators don't have independent authority in and of themselves. They have the authority to pass laws. That's what they were trying to get the legislators to do, or to pressure other members of their political parties to pull their weight on the executive officials who do have a role in the actual execution of the existing laws.
Riquetta Law. I don't know if you heard of this guy.
I have heard of Riquetta.
He says if Pisco's on a side of a constitutional issue, the safest place is to be the exact opposite side.
I mean, you say that, but I think that there are some areas that we probably agree on, and I think that there's some leeway here that we can agree on certain things.
It's certainly not on this topic, I'll tell you that.
I'm certain not on this topic, but I think on other things.
He also says Section 3 doesn't have an enforcement provision, dummy. It does not empower any state to remove anyone. Never mind that it specifically doesn't include presidents by the express language of the.
I mean, that's all conclusory, right? So those are your conclusions. You say that Section 3 doesn't have. Well, I agree that Section 3 doesn't have an.
I want to get to this because you and I were debating on this topic as far as whether it's self-actualizing, whether it's self-executing. Section 3, and you were trying to make the argument that the 14th Amendment is completely self-executing, and that's what I recall you saying. And you think in all respects it's completely self-executing. The 14th, 15th, 13th Amendments, these were all self-executing.
Well, it depends what you mean by self-executing, right? Like if by self-executing you mean you literally don't need anything else to enforce it, then I think that's a weird definition of self-executing. Because
so what is your definition of self-executing?
For constitutional purposes, what I mean to be as self-executing is not requiring a particular provision of law to be enforced. That is, the thing that creates the obligation or creates the impairment is the constitutional provision itself. So to give you an example, everyone appears to agree that the 13th Amendment is self-executing. That is, the 13th Amendment itself is the thing that freed the slaves. Now, obviously, those are just words on paper,
here's the question.
People need to enforce it, right?
Are you sure? Are you actually sure that's true? That the moment that it was and I was thinking about the 13th Amendment, and I was like, I don't even know if that actually happened. It probably made it illegal for you because you and I were debating where you took a very unusual position, which I found to be hilarious personally. Where you were basically, it seemed to me
you think I was defending slavery?
You totally were defending slavery. You were like, well, you're taking away my property rights. You're taking away my property rights. Come on.
No, that was for purpose. Come on, bro. No, that was for purpose.
I was like, what the hell? So you're saying that property rights would trump over freedom of your own person?
No, that's listen, I do not agree with that. But what I am saying is that the due process clause protects as a fundamental key liberty interest life, liberty, and property.
Right.
Okay? Those three things are textually cited.
The point to the 13th Amendment is they are not property.
Yeah. I totally agree. So the 13th Amendment deletes the concept of humans as property. It's a good thing. I agree with the 13th Amendment. Slavery is bad. It's the wrong thing to do, okay? But I was attacking your analytical framework, which assumed liberty expanding provisions are self-executing and liberty constricting provisions are not self-executing.
That is the argument I was making.
Yeah. So what I'm trying to say to you is, yes, the 13th Amendment expanded the liberty of former slaves in the sense that they are now freed from private from private discrimination and private ownership. But in terms of the government's imposition on liberty, the government imposing on individuals, what the 13th Amendment did was removed the right of individuals to own other people. And so from a perspective of government restricting liberty, the liberty that was extinguished by the 13th Amendment from the government perspective was the right to own human beings. And that was seen as acting immediately on a property interest. Now, it's of no moment. If you wanted to say, well, they didn't take away property rights, they just redefined what property was. How would you feel if someone was like, all right, we're just going to redefine property to exclude ownership of corporations, to exclude ownership of private homes, it doesn't matter how you want to cut it.
The truth, black people are the same as like some.
No, I'm not saying that. What I'm saying is that from the perspective of from the government, they're
the Democrat. I know that Democrats are.
Come on now. Hey, what I'm trying to explain is the 13th Amendment absolutely, in my opinion, was the right thing to do. But from the perspective of the government, they are removing private individuals' right to own people, right? And the people. That's why the Civil War was fought. The Civil War was fought to protect that right to own other humans, and the 13th Amendment extinguished it like that. It's to attack your analysis that assumes that liberty expanding is self-executing and liberty constructing is not.
The reason I was saying that's such a silly argument is because you're basically you're lacing into that assumption that your rights of property are the same as your right to life, which is a ridiculous. It's a ridiculous claim in general. I mean, think about this.
Why do we weigh those up? What, are those ever weighed off against each other or played off against each other? But I'm saying is for you. People die for their property, bro. People always tell me that they're going to die for their property, that they will fight for their property. That's what the Revolutionary War was about. In some respect, was about protecting property from being, that is to say, preventing the kind of unfair taxes system that would occur without representation. Part of the struggles that have existed in time immemorial have been over property. Think about Israel-Palestine. That is essentially, there's a lot of disputes there. I hate to just trivialize it. I hate to make it all about one thing, but there is, at the heart of it, there's a land question. There's a property question here at the heart of what's, come on, in terms of the dispute there's at least one of the major issues is who owns what, who controls what. People die for this thing. It's very important.
That's a red herring. Ultimately, it's a religious primacy issue, but I don't want to get into that.
It's both, right? It's both.
Religious primacy, that it's like we don't want someone who's not part of our religion owning this land. If they were Muslims who were there, but a different brand of Muslims, then in that case, there would be no complaint at all. It's the fact that they're not Muslim. It's a religious primacy argument.
Okay, I agree that religion is central there. I just want to say property, the way it manifests is through a dispute about ownership of property and control over land. And that is the only point I'm drawing from that is that property is considered a sacred right in the Western tradition.
So, Ricardo Law, by the way, says, "Oh my God, no! Section 5 empowers federal Congress. It is literally not self-executing."
Okay, that's just the conclusion. We can have an argument about that and discussion about it, but you just repeating your conclusion, that's cool, dude. I mean, I don't know what to tell you. Other parts of the 14th Amendment are self-executing, and so I think and it's not even disputed that they are, and so I think the burden of proof is on you to explain why Section 3, out of all the provisions of the 14th Amendment, is the only provision that's not self-executed. I think that you have the burden there, Rikita.
Are you confident in that? You're confident that that's actually the law, what you just said?
I'm pretty confident, yeah.
Well, I'll show you a case that says otherwise.
Where other parts of the 14th Amendment are not self-executed?
This is.
Oh, you have it ready!
Owen Bay v. Morgan.
Okay, go ahead.
256 U.S. 94, 1921 said, "How desirable it is that the old forms of procedure be improved with the progress of time. It cannot rightly be said that the 14th Amendment furnishes a universal and self-executing remedy. Its function is negative."
Oh, come on. You're taking that out of context.
There is no mandate for particular measures or reform. I actually, to be fair...
That's so out of context.
To be fair, I pulled this case up after I read that quote in the...
What that's saying is that that the Equal Protection Clause is not an affirmative grant of some amount of rights. It's a negative liberty, right? It's saying government shall not The government cannot discriminate on the basis of race. Government
Precisely.
cannot do endorse affirmative action in public funded
and that's
things.
precisely what Samara was, or Samura, I don't know how you pronounce his name, but that's precisely the point that Samara was trying to make about the 14th Amendment, that that the government cannot just simply take things away without due process. That's the entire point.
Wait. I agree that you need due process before you do a deprivation of a certain liberty interest.
And the liberty interest of being able to run for president of the United States is a liberty.
Do you have a liberty interest to run for president if you're disqualified?
100. Well, time out a second. But you're putting the cart before the horse.
Okay, go ahead.
What I'm saying is you're putting
the question is, are you disqualified? Right?
Yeah, are you, in order for you to come to the
Well,
disqualification?
I'm just starting at step one, which is I'm just
starting
at step one.
Step one is he was eligible. There's no dispute. He was eligible. He served as president for 4 years. There's no dispute he was eligible.
That's the question. The dispute is whether he's eligible.
No, the dispute is whether he became ineligible. And at what stage?
Oh, okay. Well, then we just have, that's just, for me, that's a semantical difference.
It's not simply a semantical difference. And this is one of the things I was raising to you in our discussion the other night, where I was like, there's a very big difference between someone qualifying and then taking away someone who has qualified and saying you're no longer eligible. That is a completely different thing.
I mean, do you think the same thing of like, the other qualifications where
I'll tell you why you would understand this, because there's a certain burden of proof. You know, in the same way, if I'm holding this, there's an assumption that possession is 9/10 of the law. He's holding that, he's established. So as opposed to if you were holding it, we would assume it belongs to you. If he's holding that eligibility, for you to strip that of him, you have to come along and establish it.
Why can't I say that about age requirement? Why can't I say the same thing roughly about the age requirement and the natural citizenship requirement?
That person's not established as being eligible.
Okay, but you haven't explained why. Why in one case is the starting assumption of qualification, and the other one, the starting assumption is the opposite. That is to say, for the age and citizen, the assumption is that they are not qualified. But for the Section 3, the starting assumption is that they are qualified. Why that difference?
I didn't say there's an assumption that they're
well, that seems to be implicit, because what you're saying is like,
what I'm saying is that someone who wants to run for president has to establish their eligibility. So if someone comes along, we have no idea. Let's imagine we see Vivek, okay? Someone says Vivek Ramaswamy, and your first thought is, I don't know if this guy's born in this country.
Racist, Joe. Now who's racist?
I'm saying I don't know if he's 35. I don't know if he's 35. Someone comes along and wants to make that claim against and make that claim about him because they what do you mean racist? I was saying
joking. Because you said President Shaniqua, and I giggled in the debate, and you were like, "Why are you laughing, Pisco? Why is it funny if Shaniqua was the president?"
Yeah,
and so I was just giving it back to you.
Okay, fair enough. So the point being, though, that for he's not someone who's established. Now we can set those bars relatively low as far as establishing it. But the point is that now you need to establish that you are able, that you have the capacity to fulfill Article 2 of the Constitution. But if you want to try and take someone who already has been qualified and strip them of that, that is a right that they have that you are now taking away from them. The burden of proof must be on you. Would you not agree the burden of proof is on you?
I agree the burden of proof is on the people alleging ineligibility. I'm going to
say the same for someone who comes to this country, someone who's in this country and says, I'm running for president, the burden of proof is on the United States to say you're not eligible?
Wait. Someone coming to this country is the burden of proof on the United States?
I'm eligible. If Vivek says I'm eligible, okay?
I think if someone wants to disqualify him, then the burden of proof is on them.
Some random person that you don't know comes along tomorrow, okay? And now says, I want to run. And we have all sorts of questions, whether this person was born here, lived here 14 years, and is 35 years old. Who do you think the burden of proof is on in that scenario?
It depends what the context is, right? So if it's the person who is applying to be on the ballot, I think the burden of proof is on them to produce some... for this would be just a low level, right? Just like sign an affidavit that you are qualified. Okay.
Right.
So I would produce a low level threshold to produce evidence that you are qualified. Probably the only thing I would require is for them to sign under penalty of perjury that under their knowledge they are qualified. Okay.
So that's stop talking for a second.
Okay.
You're already recognizing that there's a difference between those three qualifications. And
no. That would apply. No. I'm not recognizing that distinction.
You are, because you're talking about who the burden of proof is on. You might say it's a low level, but it's a burden of proof is on him.
No. For every no. I just want to be 1,000 trillion% clear. When you sign on that line, My version of it, my vision of it, and what I think it actually is you're signing as to every qualification, including but not limited to Section 3. So age, citizenship requirement, and Section 3, and the fact that you're not term limited, and others. Do you understand? So when you make that initial showing at every level, I think the procedures and the burdens with respect to any qualification are the same.
Where did you come up with that?
I think that's just the way it works.
Based on what?
Look at the cases where there's disqualification procedures of people who are not the correct age or who aren't natural born citizens. What happens is they sign that they are eligible and they try to be on the ballot, or they sue to allow themselves to be on the ballot. And the
Most
court,
of these ballots, in fact, I'm fairly certain the Colorado ballot doesn't say anything about Section 3 of the 14th Amendment.
Yeah, yes, they don't. It doesn't say specifically about Section 3,
but it does.
But that's a matter. That's a matter of state law. I mean,
it does say you're 35 years old. You are signing an affidavit at 35.
I'm sorry. Are you referencing the law requires that? Sorry, the law that is about enforcement of Section 3 that the Colorado Supreme Court interpreted doesn't specify Section 3, or are you saying that the affidavit signed by the persons purporting to be candidates doesn't include Section 3?
An applicant to be a candidate in Colorado.
No, but they sign that it's lawful under federal law. They are signing, affirming that they are qualified under federal law to be this thing, and so that includes everything, in my opinion, and that's what's been interpreted by the Colorado Supreme Court. Why are you laughing? It makes total sense.
I'm laughing because I'm watching a litigator who, and I learned this as a first-year law student. Okay, this is, and I'm telling you now, and here's how I learned the lesson. I was taking legal writing, and part of legal writing is you're supposed to teach us how to write a brief and how to write a memo of law and all these different things. And they also had us do oral arguments. Mm-hmm. And I've told this story here on my show before. I'll share it again quickly right here. That I was sitting there, and they basically presented us with a fact pattern, and we were supposed to write a brief for it and then argue it out. And so I'm arguing against someone else, so they put me on the side of defense, and they put someone else on the side of the government for this fact pattern. And when I went through it, and I went through the key issue of law was outrageous misconduct, which was some dicta that was thrown out in a Supreme Court decision 50 years ago, and as to where it could be an exception to entrapment, that even if someone is predisposed, if they're at the government, that they still could be claim entrapment if there's outrageous misconduct by the government. Anyhow, so when I was looking through this fact pattern, I was like, oh my God, this is crazy what the government did to this guy in this fact pattern. He must be. This is like such a slam dunk that he should get out of this. And I'm sitting there and I'm waiting to argue. And the first year who I'm arguing against is sitting as someone else was another duo was arguing, and we're sitting in the hall, and we're both really nervous. Our first time presenting any sort of oral argument at all. And all of a sudden he goes to me, I'm so glad I got the government side. There's no way I could possibly come up with any sort of argument for the defense. There's like nothing here. And I'm sitting there and I'm like, I'm thinking, are you out of your freaking mind? Like, have you, what? And what I learned at that point in time was when you are ensconced in something, because we just spent, months researching, looking into it. When you're ensconced in one side as a litigator, you tend to not be able to smell your own farts. And when you say something and you could let out the loudest rip in the world, and everyone in the room is sitting there staring at you, saying, "Oh my God, what the hell did you eat?" And you're sitting there, you'd be like, "What? It's perfect. It's perfect. Everything's perfect. Everything's perfect here." That is what ends up happening when you engage in litigation, and that's what I'm listening to from you, respectfully. With
respect to what?
You're sitting here. And you're making, and you're all of a sudden now you're saying it makes perfect sense that something that when someone is signing off their eligibility, that not only is it referring to Article 2, which is something that every kid who's taken civics class for 10 minutes knows about the 3 requirements under Article 2, but that they're also signing off on this section of the 14th Amendment that literally a third of 1% of the country knew existed.
First of all, I can't speak
January 6, 2021.
To respond to that directly.
You're saying, oh yeah, of course. Obviously, you're saying in all respects when you're signing off on it. To me, I'm like,
listen,
dude,
I am not. I can't speak for every ballot certification affidavit in every jurisdiction. I know in Colorado that when they signed, they said that they are qualified under federal law in a general sense. And the federal law, last time I checked, includes the 14th Amendment. And you might be right, by the way, about your distinction between qualification for disqualification. Just saying that the state passed, a requirement that your certification contain, I don't know, an affirmation as to all forms of disqualification doesn't mean I win. I'm just describing to you what I think the order of operations is and what I think the burden of proofs are. But it doesn't mean necessarily that I'm right. So I'm not serious.
The reason you come to that conclusion is because it's Trump.
Come on,
you would
bro.
You would not intellectually come to this conclusion unless you were trying to find some way.
This is Trump derangement syndrome. Do you understand what that is?
I understand what you're implying by that. I understand what you're implying by that. And what I'm saying to you is to say that in all of these legal arguments that you're so when you said it's unassailable, that to me is
that's me being colorful. Come on.
What I'm saying is that to say that this is a really strong decision. That's
what I'm saying.
On eight different issues, it happens to be that the guy I hate.
Happens to be. Listen,
that the guy I hate is definitely 0 for 8 on all of them.
Joe, I love you. I love you, Joe. Listen to me.
0 for 8. In that case, he's on. But it's definitely true that he's 0 for 8. That happens to be the guy I hate. That he's the guy, that's when he happens to be 0 for 8.
Joe, I love you. Listen to me.
Everyone does.
I recall, and I hate to bring this up, because the first time we interacted, I was like super on your ass about some shit. And you know what? I was being a little bit of a jackass. I was accusing you of things like, oh, you're leaving, you're running away. Inappropriate for me to do. Foot in my mouth. I acknowledge that, okay? We're way past that. But I need to call you on some shit too.
Go for it.
When I was in Australia some months ago, someone tweets at me like, hey, it would be really cool if you talk to Good Lawgic about what's going on the Section 3 argument, because that was a response to my initial reactions to reading the Baden-Paulson paper. Because initially, I was very much against this argument. And you can see my tweets, and I've actually put a compilation where I was like, I don't like this argument. I haven't really thought about it that much, and I haven't read anything about it, but on the whole, I'm a little bit scared about it. And you guys, if you don't believe me and you don't believe the tweets are there, they're there. You can read them. You can see my initial reaction to the Baden-Paulson paper and how my opinion has developed over time. And the other thing you can see there is when someone said, hey, why don't you talk about this with Good Lawgic? You know what Good Lawgic says in response to that? To do so would be cognitive masturbation of the highest order. I don't know if you remember that, you recall that, but you're like, I am not fucking talking to you about shit. This is cognitive masturbation, not about this. I'll talk to you about some other stuff, but not about this. All this is to say.
And there it is, and then I come to you and I'm like, let's talk about this. And
now you're talking about it, and guess what? I wasn't always pro gun-ho this argument. It took me time to develop it, and I understand people's trepidation, because it seems like, wait, how can this be? How can the election just be decided? But that's what it says. And if it says that,
not what it says.
We have to follow. We can disagree on that, but I think it's what it says.
Let me cover this. Don't worry, we're not talking about Palestine.
No, we're not.
Do not talk about Palestine. No, just stop. Don't worry, Debbie. We're not going to talk about Palestine. Go for Big Guy says a president cannot insurrect his own administration. Every 4 years we elect a king. Only the president can declare an insurrection. No insurrection.
Citation needed is all I need for that. Citation needed. Where does it say that? We don't have a king, and the whole purpose of our executive branch was to emulate the king's power in some respects.
I don't know. DACA kind of made President Obama a king. The DACA decision.
Come on, now you're going to say that's like a... Are you serious?
It was like he can do whatever the hell he wants. The president has a pen; he can do whatever the hell he wants, according to the Supreme Court.
No way.
That was, by the way, that was signed off on. That was signed off on by Chief Justice Roberts and all these different Republican
on APA grounds. But no one denies if Trump had done it the right way and had written the right memo, he could have gotten rid of DACA. DACA is not a legal entitlement. DACA is a discretionary non-enforcement policy. And everyone agrees that there is no mandate for the government. The core of the executive function is to have discretion on who to enforce and not to enforce. But if Trump had written the right memo and dotted the right T's, am I saying that right? Oh my God.
Dotting the right.
You don't dot a T. Right. My apologies. Crossed their T's, dotted their I's. He would have been able to rescind it, but he did it a bad way, which wasn't lawful, and he never tried again. That's an indictment against Trump. Why didn't Trump get rid of DACA afterwards? Maybe because it's a popular policy.
That's not the point that I was making about DACA. The point I was making is that the Supreme Court's decision in the DACA case basically established that the president can do whatever the hell he wants. And
No.
Laws he wants.
The opposite. Wait. The opposite. The opinion in that case said the president cannot do anything he wants. He needs to follow the Administrative Procedures Act. And or in this case, it wasn't the president directly, but his, the Secretary of Homeland Security. But to the extent that you think there's a unitary theory of executive power, it would apply to the president. And it said, Congress passed this law called the Administrative Procedures Act, and you have to follow it. So rather than it being an embracement of unbridled executive authority, it's a limit on the executive's authority to arbitrarily and capriciously take certain policies, such as the rescission of DACA. That's what they found. It's a limitation.
I haven't looked at the DACA decision in 6 years.
I encourage you to do it because it's I understand that
I remember that after it came out, like Trump saying, like Trump even making a comment like, oh wow, I never expect this. I have a pen also.
He could have but like the thing is, DACA is just a memo, right? DACA is just a memo to people that the executive branch enforces because it has discretion in who to try to deport and who not to try to deport. Mm-hmm. But Trump could have gotten rid of it if he wanted to. That's one more reason, by the way, those of you who are watching who support Trump's perspective on immigration, why didn't he try to get rid of DACA the second time?
Oh, that's a fair question about his policies. I mean, that's not really relevant over here, and I want to sort of stick.
Okay. Yeah. Sorry. Go ahead.
No, it's okay. I raised DACA.
Sure.
But I want to get back into this self-executing argument over here. So when we have Section 5 of the 14th Amendment, which says the Congress is going to pass laws, and you basically try and interpret it the same way as the Supreme Court of Colorado interprets it, which is essentially saying that means that Congress can do it, but not that only Congress can do it, anyone can do it. Now, can you tell me when you're putting that read on it, how pragmatically is that supposed to function? That based on your argument here, you would have 50 different states reaching 50 different conclusions about every single individual. Forget about just one Trump. Okay, mm-hmm. you could have 50 different states reaching conclusions about dozens of people who were at January 6th or at the Chaz or at somewhere else, and say that applies that this state says that the person's okay to run for Senate. That person says it's how would that possibly function?
Yeah. So here's how it functions, right? For most offices, not every court's going to have jurisdiction over the Section 3 enforcement of every single office in the country. So as a practical matter, right, the courts that will have what did you not understand? So the presidency is a unique position because the presidency is 51 elections that pertain to the same office. Right. And so you could have horribly inconsistent rulings here that affect the same election. That is, so it is the case, even under my theory, that even if the Supreme Court says, hey, he's ineligible, there could just not be a way to enforce that in certain states. I accept that could be the truth. I don't know, actually, how the Supreme Court would craft a remedy that is by its...
According to you and your understanding of state power with electors, even if the Supreme Court decides in his favor that states don't have that power, Gavin Newsom can wake up the next day and say, I'm passing a law here that Trump is not on the ballot.
California could pass a law that gets rid of the vote for president and just allocates everyone to Biden. That's just true. Now they're not going to do that because they're not going. It would be political suicide to say we're stopping elections for president. Okay.
To me, for anyone to think that such a thing would ever be deemed constitutional.
Bro, it literally is. Just look at how it was done.
Not just because, even like I said, I'm not familiar with how things were running 240 years ago. I am familiar with the way things have been running for the last 200 years. And for the last 200 years, no state out of the 50 states has ever come to the conclusion that sure, we can just decide that we're just going to pick who the electors are for our.
They haven't done it. They haven't done it. Yeah, for sure.
Wake up and say, oh yeah, they're just going to whoever wins the Republican primary here.
I mean, just look at Article 2. Article 2.
Just stop for a second.
Yeah.
Instead of talking theoretically like we're a bunch of dipwads, okay? Let's just talk reality here. Reality is, and I don't need to go through the Constitution and tell you that as well as I do, that if any state actually tried doing it, that would never hold legal water.
It absolutely would. I'm telling you it would.
You're out of your mind.
I'm telling you the Supreme Court has literally said as much. Bush v. Gore, you could argue it's dicta, but
what did they say?
So I'll pull up the quote from Bush v. Gore, and hopefully it'll resolve things. I'll absolutely get it for you. Just give me literally. I know I'm saying literally a lot, but give me 30 seconds.
You pull that up while I get to some of these super chats, okay? So I got a bunch of. So John the Great says officers are appointed, not elected. The joke that an office makes you an officer is moronic. The use of the word officer comes from military applications.
It's just not true. The Constitution refers to civil officers, so
they're not officers of the United States, though. That's where I think you struggle.
Oh, you don't think civil officers are officers of the United States?
No, I'm saying officer of the United States. Officer of the United States is a term of art, which is different. That officer of the United States by the Appointments Clause refers to someone who's appointed by the president. You're not otherwise.
Under the Appointment Clause, yes, but that doesn't result just because it says that the president shall appoint officers of the United States doesn't mean that those are the only officers of the United States.
Then how does someone become an officer of the United States unless the Constitution is what empowers someone to make someone an officer of the United States?
Or you are either appointed or you are elected by the Electoral College.
But where you see that's considered an officer of the United States?
Every other part of the Constitution and the plain meaning of the words. And
no. It doesn't say officer of the United States. That's where you seem to be having an.
What else would you be an officer of? What's the president officer of?
Someone can be an officer, as he just said, in a military capacity.
Okay, he's both a civil and military officer. President is a civilian officer, but he's also a military officer. It's a dual role.
How do you know that? How do you know it's a dual role? He's a civilian officer.
Because he's the commander-in-chief of the armed forces.
That's the officer part.
That's the military part.
Right. That's the military is the officer part.
The military is the officer part. No.
What?
Because
based on what?
Justices are not military. I don't know what to say. It's just not the case.
No, what I'm saying is, when they refer to him as an officer, it's in his military capacity, not as in his executive capacity.
Oh, you're saying specific to the president. When they refer to the president as an officer, they're referencing the military aspect, not the civil part of it.
Precisely.
I don't find that available.
That's consistent. That's consistent with how the Constitution uses the phrase "officer of the United States."
I don't agree. I think that the impeachment clause, for example, applies and disqualifies people with respect to office under the United States, and included in that is the civilian aspect of the presidency as well as the military aspect of the presidency. So I think it includes both. Here's the quote that I'm referencing from Bush v. Gore. This is per curiam, that is by the court in Bush v. Gore. Quote, "The individual citizen has no federal constitutional right to vote for electors for the President of the United States unless and until the state legislature chooses a statewide election as the means to implement its power to appoint members of the Electoral College." So, history has now favored the voter.
So unless and until, read that part again?
Unless and until the state legislature chooses a statewide election as the means to implement its power to appoint members of the college. But hang on, we'll keep reading. This is the source for the statement in McPherson v. Blacker that the state legislature's power to select the manner for appointing electors is plenary. It may, if it so chooses, select the electors itself, which indeed was the manner used by state legislatures in several states for many years after the framing of our Constitution. History has now favored the voter, and in each of the several states, the citizens themselves vote for for presidential electors.
Okay, so the point being that now once you passed a law passing that power on, to all of a sudden say that Gavin Newsom has the ability to say, we changed our mind, that and suddenly reverse that, I think I think he would struggle with that.
We'll keep reading. When the state legislature vests the right to vote for the president and its people, the right to vote as the legislature has prescribed is fundamental when it has, right? And one source of its fundamental...
States have.
Yeah, yes, true. And one source of its fundamental nature lies in the equal weight accorded to each vote and the equal dignity owed to each voter. The state, of course, after granting the franchise in the special context of Article 2, can take back the power to appoint electors. This is a majority in Bush v. Gore.
I need to see the portion of it to see what is the ruling of law that is looking to that needs to cite that for that it's not dicta.
I think it arguably is dicta. They don't need to resolve. I mean, essentially, they're laying out the structure of why there's an equal protection violation in how Florida did their recount process in the 2000 election, and part of that analysis requires that there be a discrimination on a fundamental right. Right. So if voting for president is a fundamental right, then the equal protection has heightened scrutiny. Right. Mm-hmm. And so the equal protection aspect, now you don't need to decide that the states have the power to take back the vote to decide the question of whether or not voting is fundamental once offered. So in that sense, you could argue it is dicta, but it is an authoritative statement and pronouncement of the Supreme Court, which is absolutely supported by the constitutional text.
Yeah. I think that I think that
you disagree.
I think we're dipping into that masturbatory cognitive exercise.
I'm just going the way that you're pointing me. I mean, I say something off the cuff and it interests you.
What I'm saying is because I think it's an extension of the law. The reason I brought it up is because I was saying by your argument this would be true, and you were like, and then you doubled down and said yes, I agree that is true, and I was like that's kind of ridiculous. I think that's kind of ridiculous.
I'm telling you, the California legislature tomorrow could end all elections for president, and there would be nothing unconstitutional about it. I don't support them doing that. To be clear, I do not want them to do that.
I know you didn't say.
Yeah. I'm just saying they have the power to do it because we always have to keep in mind, and the reason why it's important and relevant is states appoint electors, not the people. Now, the states have given the people the right to vote, and in that sense, the vote is fundamental since they have chosen to offer the vote. But in reality, even though it feels like a national election, it is 51 independent elections.
I'm trying to look at this impeachment clause. What was the reason you brought up the impeachment?
Oh, yeah, sure. So, and this is on page 73 of the Colorado opinion. I think it's a really good point. Consider, for example, the impeachment clause, which reads that Congress can impose, as a consequence of impeachment, a disqualification to hold and enjoy any office of honor, trust, or profit under the United States. If the presidency is...
Okay, go on.
I understand that this is for purposes of the under the United States analysis, okay? If the presidency is not an office under the United States, then anyone impeached, including a president, could nonetheless go on to serve as president. This reading is nonsensical, as recent impeachments demonstrate. The article of impeachment brought against both President Clinton and President Trump asked for each man's removal from office and disqualification to hold and enjoy any office of honor, trust, or profit under the United States. Surely, the impeaching members of Congress correctly understood that either man, if convicted and subsequently disqualified from future federal office by the Senate, would be unable to hold the presidency in the future. So that's the argument that the presidency is an office under the United States. If you agree that the presidency is an office under the United States, how can this be anything other than an office? How can the president be anything other than an officer of the United States? Does that make sense?
Yeah, and the answer is precisely what I just told you, that he's an officer in his military capacity. He's not an officer in his executive capacity.
But who cares?
Well, the reason.
Why does that distinction matter? Section 3 doesn't make a distinction between military and civil.
Because your reading it makes the Constitution contradictory upon itself with the Appointments Clause. Because the Appointments Clause specifically says that he's the one who commissions all officers of the United States.
I don't view that as an exclusive recounting of everyone who is an officer of the United States. I think it's just saying that the president appoints officers of the United States other than himself. and the vice president.
All right. And so I expect that any argument I'm going to make, you're just going to say, well, I just don't.
I'm going to dispute all the arguments because I believe the opinion is right.
Right. Well, and you don't believe in Griffin.
Oh, I don't believe in Griffin. That's right. Yeah.
You don't believe in Griffin. For those of you who are new and aren't familiar with Griffin, so the Griffin case was decided by Chief Justice Salmon in 1868. Shortly after the 14th Amendment was ratified. And as I explained this in Discord, but I'll explain it again here. So the Griffin case was a man by the name of Cesar Griffin was convicted of, it was down south, and he was convicted of murder after the Civil War. So shortly after the Civil War, after this 14th Amendment was passed, he was convicted of murder. And he said he tried to attack that and get out of jail. In fact, the court agreed with him. The appellate court agreed with him initially. His argument was that Judge Sheffy, who presided over his conviction, was an ineligible judge because he said, hey, whoa, hold on a second here. Section 3 of the 14th Amendment says if you took up arms, you're automatically disqualified. Well, Judge Sheffy participated in the Civil War. So therefore, under Section 3 of the 14th Amendment, he was ineligible to preside over my trial. And since we didn't have a proper judge, a legal judge, therefore the entire trial has to be thrown out. And the appellate court agreed with him and said, yeah, that's right. It ended up coming before Chief Justice Salmon, but not the Supreme Court. He was riding circuit. And he wrote out a lengthy opinion, which is not binding on this court because it was not a Supreme Court. It's not considered court precedent. So I am in agreement with you from a legal perspective that it is not binding on him. But it is certainly considered, it's certainly to me, and I think to anyone who's actually approaching this fairly, like
you have to deal with it. You have to deal with it 100%.
Times more influential than two schmucks who woke up yesterday and said we're now the scholars on this, and we're named Ballot and Paulson, and that now we're the experts and we understand this really, really well, far better than anyone else ever understood it, including Chief Justice Salmon, and that we think that it is self-executed, because what Chief Justice Salmon said was Section 3 of the 14th Amendment is not self-executing. It just doesn't automatically kick in. In fact, we need Congress to write further legislation to tell us how this works, because until they do that, there is nothing here. That is what he wrote in the Griffin opinion. That is, which is very compelling. And subsequent thereto, in 1870, Congress came forward with the Enforcement Acts, where they were basically trying to give effect to this. And those Enforcement Acts lasted for decades until they later were repealed. The point being that was the understanding of the Section 3 of the 14th Amendment by the contemporary Chief Justice of the day when this amendment was ratified. And that seems to be the understanding of Congress of the day, and that shortly thereafter they turn around and like, oh, okay, let's pass the Enforcement Act so that this way we can give effect to this. Now, Ballot and Paulson and my esteemed guest over here are the opinion that Chief Justice Salmon's wrong. I guess Congress wrong. Ballot and Paulson know far better. So I want you to walk me through this. Walk me through the illogic of
Griffin.
Of Griffin. Yeah, walk me through it.
Yeah, so I think that the central reason why I think the case is unconvincing is its focus on the argument from prudence. Okay? And this is a key concept that I think people, and I think you'll even agree with me on this, which is if the Constitution requires something that is like inconvenient or might lead to like political polarization, or might be like uncomfortable to deal with, it doesn't matter, right? We need to follow what the Constitution says. Whether that's disqualification or not disqualification, there is no discretion to enforce or not enforce the terms of Section 3. Agreed? I think you can agree on that. Like, there's no like, if the Supreme Court agrees that Trump is disqualified, they don't have a discretion to say like, well, but we're not gonna, in this one case, we don't apply it, right? They don't have the discretion. If he is disqualified, he's disqualified. You feel me?
I'm not sure I understand. I'm not sure I understand what you're saying. You're saying if the Supreme Court finds that it applies all these 8 things, that they all fall out that way. They don't have the right to then turn around and say, but we're not going to apply.
This would be uncomfortable. Right. What I'm saying is, like, we need to follow the Constitution, right? We can't have these arguments about, whether democracy, anti-democracy. You can make arguments for either side, in my opinion. But the point is, we have to follow the Constitution, right? Just like the Second Amendment. We can have disagreements about what the Second Amendment means, and you can have disagreements about what Section 3 means, and we can argue on the law. But we can't be like, we're ignoring the Second Amendment, and we can't say we're ignoring the First Amendment, even when it's inconvenient, even when states would like to pass laws that, like, ban all guns or ban all speech or do whatever shady stuff in other parts of the Constitution. We need to follow the Constitution and the law. I think we should all be on agreement on that.
Correct. Yes.
Okay. So that kind of central premise, I think, is not apparent either in Griffin's case or really just in the general discourse that you're hearing, right? Like, you're hearing a lot of people being like, look at how hypocritical the Democrats are being, or look at this, look at that. That's not the point. The point of this is only to decipher what the Constitution means and to enforce what it says. And so when you look at the quote from Griffin, which I know that everyone cites this quote, and so I'm going to pull it up now. Just give me a second to find it.
I'm gonna pull up some super chats while you're doing that.
Yeah, go for it.
Actually, I'm gonna get some Rumble rants. The BA Crim says the fact that Trump does not take an oath in Section 6 of the Constitution means that the 14th doesn't apply. I think the Dems just handed Trump the election on this.
This is literally the worst argument there is, though. The oath argument, I think, is even worse than the officer argument.
Well, they actually bring up the oath argument, and I'll tell you something. I'm not a fan of the oath argument either. I'm not, because and that's why I don't want to engage on that one, because I don't that one I'm like, yeah, that's probably the weakest argument, because to me, even though he's making a different oath, I think that the language of the amendment can easily be read to say any oath that's in any way.
Yeah, it's the most broad, right?
Yeah,
it's yeah.
So
this is the sorry. Go ahead.
He also says, and this one I'm going to give him a thing for. It says, can the Supreme Court rule that there was no insurrection by Trump?
Yes. Engagement, no engagement. I don't think they're going to rule there was no insurrection on January 6th, but they could absolutely rule that Trump did not engage in that insurrection. And this is how the argument might go.
I will tell you this. I think that it's the least, what I think a lot of people on the right are hoping for, and is almost certainly the least likely thing to happen, is the Supreme Court coming to determination that there was no insurrection.
Yeah.
I don't think they're going to touch that with a 10-foot pole.
Yeah, if they're going to rule against this case, I think it's much more likely to engage. And this is how the argument might go. Trump didn't incite, and if he didn't incite, he didn't engage, and if he didn't engage, he's not disqualified. Okay, because the Colorado Supreme Court relies on incitement, and so if Trump did not incite, there's no evidence before the Supreme Court that he engaged. The only thing that is before the Supreme Court is going to be whether or not Trump incited, therefore engaging.
I want to get to the incitement thing.
Yeah, sure.
How much? I just don't.
I have like maybe 20 more minutes, but I just want to quote this from Griffin, and then we can maybe move on to the actual merits, if that's cool.
Yeah.
Sorry, this has been a lot of fun, and we can do this again for sure. I love talking to you. I think that you have even though I disagree with you a lot, it feels good to disagree with other like people who are interested in this kind of stuff, and so it's nice to do it. This is the quote from Griffin. In the examination of questions of this sort, great attention is properly paid to the argument from inconvenience. Argument from inconvenience? How can that be a basis to say that what is demanded is Congress action, right? Like, inconvenience is inherent in constitutional provisions. Yes, provisions are inconvenient as hell. They're designed to be inconvenient. The Equal Protection Clause is inconvenient to a lot of government actors. The First Amendment is extremely inconvenient at moments, but we enact inconvenient provisions so that they are inconvenient. The whole purpose of our Constitution is to make inconveniences to put checks on the government and checks on unbridled uses of governmental authority. And so structuring your argument around prudence and the consequences and inconvenience.
You keep using that term prudence, and I'm not sure what you mean in this context with the term prudence.
When I say prudence, I'm saying like the essentially one's intuitions about outcomes. Okay, if it's not, like, for instance, it would be prudent of you to shower every day. Why would it be prudent of you? Because showering every day produces good results for health, for smelling good, for being around people socially, all that stuff. So when I reference prudence, it's about people's notions about what like ends up in good results. Okay.
Okay.
And so I think that the Griffin opinion relies on like what would happen if the outcome is as certain people argue. If it would be such a horrible outcome.
You're saying when I say it doesn't make any sense for 50 states to have 50 different conclusions, you're saying I'm saying it's imprudent to find your
right. Like we should first and foremost be concerned about what it is these words mean. Now you can make an argument that it's absurd, right? If there's an absurdity part to it where everyone acknowledges that absurd readings are not preferred. But as you are aware, absurdity doctrine is like a high threshold, right? You'd have to be like, it's absurd. One of the arguments I think that sounds an absurdity that you have offered is, well, we shouldn't interpret this to be enforceable by states because did you really think that they wanted state governments who were, some of which were insurrectionists, to be enforcing a prohibition against insurrection? That's kind of like one of your arguments that sounds an absurdity. And truly absurd results are relevant, but anything other than that, I think, is not.
And what I'm saying is your reading as to the state's abilities to do this does come to truly to something that's going to be truly absurd. I mean, the idea that we would have 50 different states reaching different conclusions about anyone who runs for president, even if you were limiting it to just the office of presidency, which you came with some sort of philosophical argument to say that that's where it would be limited to. But even if it's not, even if you don't limit it to that, that to me doesn't make sense to say. Well, I mean, that's such
the response. The response to that is that these are 51 individual elections, and we think of them as unified. And in the sense that, you know, they are for one office, and so it is unique in that sense.
That doesn't make
that these are 51 elections.
From the perspective of 300 million Americans, because 300 million Americans,
I understand
we all recognize that it's 50 different elections on an intellectual and from a legal perspective. But that doesn't mean that anyone gives the slightest damn about what their state does compared to what happens on a national level.
That's my argument for why there should be no electoral college.
No, because ultimately, no. I'll tell you why the electoral college is important, and I'll tell you what in the presidential race specifically. It's because you actually inherently recognize by your belief in federalism that the cultural attitudes and the mindsets and morals and mores of people are vastly different in Nebraska versus New York, in New York versus California. Versus Dallas. Even when you're talking about like Democrats, right? A lot of people talk about blue cities.
Democrats are very different between localities, 100%.
Vastly different. Not even like, I'll tell you something, there's a lot more homogeny amongst the Republican Party than there is amongst the Democrats.
I 100% would agree with that.
So my point is this: the values are so different from one locale to another, even in the same part, even in parts of one state, but you can't break it down into like into 40,000 different elections. So what we basically come up with is, okay, this is the way to sort of actually have some sort of deference to locality and the difference in attitudes as to what's healthy versus what's unhealthy, what's beneficial for the future versus what's less beneficial or potentially harmful for the future. That we say, you know what, each state is going to decide for themselves what they're going to do. And that's why I was saying, by the way, that this compact is such a horrible thing, because you're basically saying that the values of people who don't live in my state matter just as much as the values of the people who I'm supposed to represent. To me, that's.
But there's a kind of, I don't think it's necessarily hypocrisy, because you could have ways of arguing why this kind of federalism makes sense for the election part, but not for the disqualification part. And I think you could even make a convincing argument that disqualification should be uniform with respect to the president. And I would even argue that whatever remedy the Supreme Court constructs, there should be a way to enforce it uniformly. And I would hate the situation in which states come to inconsistent.
You know what that way is? If you
not disqualify,
no.
Or congressional enforcement and displaced state.
Federal level, it's a federal level, not a state level. You know what? If they went to federal court in Colorado, and that was their basis, this would be a whole different.
No. It wouldn't be. The thing is,
entirely different
this because lower federal courts are not required by the Constitution, right? We are all assumed we live in this world in which federal courts are reality we live with. But don't ever forget the Madisonian Compromise of the Article 3 courts, which is Article 3, read it, establishes one and only one court, the Supreme Court of the United States. And it establishes one and only one judge of the United States, the Chief Justice of the Supreme Court. Every other justice and court is a product of law, and Congress does not need to have lower federal courts, does not need to have any justices or judges other than the Chief Justice. Okay? Relevant? It's relevant this way, right? It assumes that in the world not traveled, where there are no lower federal courts, and there is no other justices other than the Chief Justice of the United States, in that world, states would have to enforce in courts these provisions. You feel me? So if federal courts don't have to exist,
ratified in that world? No, it wasn't.
No, that's correct. It wasn't.
It was ratified in the real world where there were federal courts all over the place, and every state had its own federal court.
But they're not required. They're not required.
It doesn't matter if they're required. When they're passing this.
So what happens if Congress were to get rid of the federal?
Well, they're coming to this conclusion based on how things are existing. You know what? They didn't have to necessarily be dealing with the determination that the Civil War was revolution. They just they happened to pass. Or you think they happened to pass this right after the Civil War, and it wasn't specifically a reaction to the Civil War? I mean, come on, stop trying to pretend that.
Okay, then you tell me what happens. What happens if Congress gets rid of the federal courts tomorrow? How does Section 3 get enforced?
What happens if tomorrow all of a sudden there's that 3/4 of the Senate, the Senate says we're never going to meet for the next 2 years? How is that relevant? Just because there could be a hypothetical situation doesn't reveal as to what the thinking of Congress was when they actually ratified this amendment. See, this is where I'm saying that you're not smelling your own farts. That you're saying that you can basically, I don't know, pop a doobie and say, you know what? Technically under the Constitution, this could be a reality, and pretend that that's the world that this was actually ratified in. And you know it's not true. You know that's not what was going through their minds. Or like, let's see. What if there's only one judge left on the entire planet, and we call him Solomon? Federal
judge now.
One judge.
The state courts are assumed.
That's an asimine argument.
It's an argument.
It's an argument because it's not an argument you actually believe.
No. I do. I believe it wholeheartedly. That is that the courts have been consistent. That state courts will very often enforce federal law. If you're aware, back in the day, there was very limited federal jurisdiction in terms of what cases they were allowed to hear. State courts were assumed to be able to enforce sometimes even federal criminal law, right? So the displacement of state courts' jurisdiction from federal issues is a choice. Right. But if you read like the precedent here, the assumption always is that state, because of among other things, the Madisonian Compromise, because state courts are assumed to be competent to hear those questions, and they're an assumed fabric of our union. Remember, the states predate the Constitution. The Constitution takes the states for granted. The states existed prior to the Constitution. Constitutions did not bring the states into being.
Objection, relevance.
It's relevant because our default principle should be that states enforce federal law in terms of like state courts enforcing federal law. That's the default presumption.
That is not the default presumption. The default presumption is that subject matter jurisdiction lies with federal courts on matters of federal question. That is the default. Now, can states shoehorn their way into trying to decide issues like that? Yes, but let's not pretend that the default is that that's something a state court is supposed to be deciding.
It literally is the default. There's Supreme Court precedent on that.
That's the world that Congressman Stanberry or whoever it is that's ratifying this is ultimately living in. That they're thinking, this is gonna be handled by some state. Think about what you're saying. That they're basically like, who's going to interpret whether or not someone can actually run for president? You know who's going to determine that? Some jackass in Georgia that we just burnt down. That's going to be some judge there who just put down his arms because we had to bludgeon him into death in order and kill off half his family. He's the one who's going to basically decide whether how we apply this amendment. That's the thinking that you think is the most logical thing in the world. That's what Congress had in mind. That the federal power, this was all about a fight for federal power. It was all about a fight for federal power. That fight is that after they're writing this amendment specifically so that they can cede away federal power to the states for individual states to reach that conclusion. To you in Dookie land, where you're like, well, technically the Constitution says that it's only one judge. That's the world they were living in, rather than, hey, we just came back from a freaking civil war and we want to make sure that we don't have any of these freaking insurrectionists in here that the South is going to send up here to sit in our Senate. I'm going to sit next to one of these jackasses who I was just firing. Who was just leading. It was just the captain of an army against me 6 months ago, and I don't want them sending them up here. So you can understand them saying that, and we also want them to know that when you're sitting here saying that state sovereignty is what rules, and if we want to leave, we can leave anytime we want, and we just gave a massive FU to them, that the federal government is what pervades. And now you're coming along and reading this amendment, which is specifically designed to stop that, as empowering states. I mean, think about how that's why I say it's asinine, because it's like completely you're divesting yourself of what reality was in 1868.
I don't agree with that. And when I'm saying that states are assumed to have concurrent jurisdiction of enforcement of federal law, I'm just citing like well-established unanimous Supreme Court precedent. There's a case called Taflin v. Levitt, 493 U.S. 455. Unanimous opinion by Justice O'Connor. Rest in peace. And I'm just quoting the Wikipedia summary. Okay, I don't have to quote I could go to the decision itself, but I'm just citing the Wikipedia summary. I knew this case offhand because I've taken federal courts. But it states, in a unanimous opinion written by Justice O'Connor,
what case are you citing now?
This is Taflin v. Levitt, 493 U.S. 455.
So a century after this amendment was ratified.
Yeah, sometime after. But
so you think this is what they had in mind when they ratified?
They're interpreting the original Constitution. They're interpreting
the and not recognizing that when we talk about originalism, we're talking about reading statutes and amendments when they were ratified. Originalist doesn't read an amendment that's written in 1868 as if it was written in 1789.
I agree with that, but the court in Taflin v. Levitt is interpreting the inherent dual structured nature of our constitutional system and arguing essentially that and deciding that unless there's a displacement of state authority, state courts are assumed to be able to enforce federal law. That's by the way, that's true of the Equal Protection Clause. State courts enforce the Equal Protection Clause. State courts enforce the Federal Due Process Clause, and they do it.
When did that start?
When did state equal protection claims start?
Yeah. When did that start?
In the 19th century.
When?
In the 19th century?
It was an outgrowth, actually, of these amendments.
Well, yeah, because the Equal Protection Clause didn't exist before this amendment.
That's my point.
This amendment brought it into being.
You're right. That's precisely my point. So you're sitting here.
I'm missing the. Oh, sorry. You'll have to explain to me.
Saying that's what they were envisioning, that states are going to be, but the entire concept was such a novel concept that for you to say that they're on this particular issue that they're assuming that that's going to be ceded over to them, that is.
No, I'm saying that the forward-going practice of the courts in enforcing the Equal Protection Clause, enforcing the Due Process Clause, shows that people understood that these provisions were to be enforced by the states. That's all I'm saying. I have to go in like 5 minutes, but I don't know if there's any last minute. We haven't gotten to incitement yet.
We haven't gotten to incitement at all. So
we could save it for another day, or we could do a little bit right now.
I'm trying to figure out when I can get you back in here, because
whatever. Right? We could wait until there's some movement by the Supreme Court and get back to it and see what they say.
Maybe we'll see when Trump files. And
yeah, sure. Yeah, and that would be a very interesting thing to look at.
Because that'll probably, I'm sure he'll bring up the incitement.
100% he will.
All right. Well, I apologize to those of you who sent me super chats. I didn't get. I don't know. You have a chance to sit for like 5 minutes, then we'll try and run through some super chats here.
Yeah, 100%. 100%.
Okay. Did I miss you mentioning Maine, Polar, Colorado? We mentioned it very briefly. POTUS is both an officer and who appoints and commissions officer. And I said that he's an officer in the military capacity. But Congress is ready to determine what an insurrection is in criminal law. Yeah, and that's another issue that we never got to cover, which I think that the Colorado,
whether or not that displaces other forms of enforcement or other standards. And I would say that it doesn't, but obviously Supreme Court could disagree with me.
So founding of the United States was an insurrection, and we declared it through the Declaration of Independence. I guess
it absolutely was an insurrection. Yeah,
that was.
Yeah,
that's inarguable that it was an insurrection. Is it an insurrection when you engage in disrupting a public meeting such as a city council meeting or disrupting and confirming a hearing for SCOTUS?
Everyone has a seriousness threshold, even though they don't want to admit it, right? And whether or not force is applied, like, does that include throwing like a feather, right? So there's going to be some close calls and margin calls where it's like, okay, does disorderly conduct count as insurrection? Mm-hmm. Is it using force? Everyone, right, has those thresholds.
By the way, when I think that even if assuming that this were classified an insurrection, which I was saying the other day, it's a close, which I don't think it is. I still don't think it's an insurrection. But even if you're labeling it an insurrection, as far as engaging in insurrection, I don't think everyone who went into the Capitol is engaged in insurrection.
I don't agree. I don't think they all were either. I don't think everyone there is engaged in
insurrection. In fact, I think the overwhelming majority of them might not have even known about the violence that's happening elsewhere in the building.
I think that the majority of the people who broke the laws and went into the building, I would say, were engaging. Okay, unless you were going in there, the only difference is
and they see people just ambling on in there like it's like a freaking guided tour.
Right. So the exceptions I would provide for are people who genuinely did not have an intent to stop the steal. So people who did not have an intent to stop the steal, people who were like, let's say that you were literally going there to like do reporting, or the reason you're in there is to get your friend out of there. There could be people who are in the Capitol that day that weren't engaged in insurrection, and certainly people who remained lawful, people who did lawful things. I wouldn't say, and that includes the vast majority of people that day. I don't disagree with that, by the way.
I think the people who are screaming for Pence to quote unquote do his job and count the other slave electors and send it back to the states for the states to decide who the president is, that they were that was operating within the bounds of the Constitution, at least as the
Constitution just time. Mere advocation is
inside screaming. If they're screaming "Hang Mike Pence," that's a different thing than if their sole objective is not to cause him harm, but to encourage him to do what they felt was his duty to do.
I agree that for any particular person, if you never used any illegal force or threat of force
in there without force.
Yeah, well, I would think that many people who entered, I think that mere presence can be force, and this is so just to be clear, if someone enters into your home, breaks into your home, I would say that is an application or threat of force, but again, you need specific intent. So that's why I don't say that everyone who entered the Capitol that day.
Sure, people at home, my audience is screaming, "It's the people's house." They're not breaking into a home, but
come on,
that's where they're screaming that. I'm sure there's at least 5.
You guys love property, and you guys would never. If you try to attack a military base or something, or like let's just take the police precincts that BLM attacked. Do you think the police has an
house?
What? Because one's a legislature and all right, then we'll take the people's house. Do you think that if a bunch of BLM people tried to enter into the Capitol to like I don't know, to steal shit, you think that the Capitol Police would have a right to defend it?
I don't know.
Of course they would.
Rashida Tlaib stood up for the Free Palestine people. I'm not getting to the Palestine. My point is, we've seen it happen in Congress.
Okay, we won't get into
that. We've seen it happen in Congress.
Oh, you're gonna bring out the Brett Kavanaugh hearings and all that stuff? That is not the same.
No, but okay. The last thing I have a question for you on is this: he was Jack Smith, who seemed to try and find any possible crime that he had committed, and did not even go after him on incitement or insurrection or anything related to insurrection on the 18 USC 2383. He didn't. Not once is there even a charge about because
that is correct.
And I think you would probably agree that he recognized that under Brandenburg that would be a loser.
I don't know what's going through his head, but I think.
Come on,
I don't know.
And you're sitting in his office, and you're asking this question.
Here's what I think. This is me just.
Say, dude, we would get killed on Brandenburg.
I'm 100%. When I'm talking about this, I'm honest. I'm just giving you what I think. So I think that what they were discussing is like, should we do this? And like, what we're about to go after the president for at least these conspiracies. Should we tack on this insurrection or the insurrection or seditious conspiracy charge? Those are the ones that would be the hardest to prove. And so I think that Jack Smith, using his discretion, he wants to get convictions and he doesn't want to muddy the waters. He wants to streamline this. He took other things that are consistent with that approach because, look, he didn't charge the co-conspirators that Trump is alleged to have conspired with as part of the DC indictment. And so that, to me, indicates a mindset of trying to indict on the cleanest possible charges that don't require the most amount of dispute. And so that's.
But how? Let me ask you. But on the same vein, even forget about Trump for a second. This is a great point that Ed brings up here. Nobody was charged with insurrection. So you're basically saying he incited an insurrection that 0 people were charged with.
He incited insurrection that no one was charged with. Correct. But that's none about that. None of that is inconsistent. Right?
No. That sounds to me to be ludicrous.
Why is that ludicrous?
Because what you're essentially saying is this. What you're essentially saying is that this statute here, this Section 3 of the 14th Amendment, is not only are we going to read it to try and find some way that applies to the president, and forget about the whole oath thing and that problem there, and that it's barring. It's not just who's triggered, what position is triggering it, but who's barring it. Then we're going to say on top, of that states have the power to decide this and not federal power. And then finally, we're going to say that this is an incitement of a crime that no single human being has been charged with. And we're going to say you don't have to fulfill a criminal yardstick of
They're just different things. One is a criminal statute. They're different.
But a clear and convincing thing that no person has actually been charged with, and he used words, and not words in one occasion, but apparently there's this crazy buildup that's happening over months.
We'll get into that because I'd have a lot to say about that. Yeah,
and at what moment he's engaging in incitement, I have no friggin' clue because
they make it clear. The speech is the incitement.
If the speech is the incitement, then it doesn't matter what happened afterwards.
It does matter. You can understand. Yes, it does.
No, it doesn't matter at all because whether people went and did stuff and didn't go and didn't do anything, it wouldn't matter.
No, I agree with you that at the time the speech is given, that's the incitement. But what happens afterward is relevant evidence of intent. Just like if you murder someone, you could do a bunch of stuff afterwards. The murder occurred when you murdered them, but things you say afterwards, things that you
do afterwards, you can only show manifest an intent if there was some sort of prior communication between them, meaning there's some sort of way of knowing that they're going to interpret it this way.
No. This is interpret it that way. The afterward stuff plays into the reason why. Here's like an example. So, are you familiar with the Chris Watts murder? That murder where he annihilates his own family, and there's like a video of him backing up with his. Well, your audience might be familiar with that murder, or that fact pattern, but essentially, it's a super sketchy situation. The family goes missing. The police officer comes in and starts talking to him, and he acts all nervous, and he starts saying stupid things, and he's sweating hard. It is the case that everything he says there is, quote, protected speech, but he's not being punished for the speech itself. The speech is circumstantial evidence of his guilty as fuck intent that he annihilated the family. And the way normal people look at statements, they are evidence that can be used against you in a court of law. Even though the statements themselves are not criminal, they are evidence of your intent. And in this specific case,
the only thing that could be would be the statements he made, not actions taken by other people. Meaning, if people did something illegal and he said something like, "Oh, good, finally," that could be manifesting
what they're saying is there's an adoptive. They don't say these words exactly, but the logic of it is it's kind of an adoptive admission. If you didn't want this to happen, you would expect someone who didn't want this to happen to come out and say that. Okay, that's what the logic is. Just like, think about this, right? If you were in a murder case, right, or I'm not saying you, but a random person in a murder case, and he's saying like, I had another reason to be out that day, and the reason the reason I wasn't there was because blah 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 blah, whatever it is, and the prosecutor says, don't you expect that someone who blah 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 would have da 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 da, but he never did that, did he? So that is perfectly in bounds for us to use the action or lack of action as evidence of intent.
He did tell them to stop.
Okay, yes, he did. At some point, he told him to stop. I agree.
Yeah. But
we'll get into why I think that's unavailing.
I guess that manifests that he had zero intent.
I don't agree with that, but we'll get into that.
I'll tell you this much: the fact that in that 200 pages of that Colorado Supreme Court, they managed to somehow omit the phrase "peacefully and patriotically."
No, they don't. They talk about it.
No, they didn't.
Yeah, they did.
Fairly certain you're wrong.
No, they're like, we're not going to take, like, the fact that this was said an hour before he called on them to fight like hell is not controlling on our interpretation of
or the fact that every politician says fight like hell.
No, but it's not just the words themselves in a vacuum. It's the words in context. Well, I know that sounds weaselly, but it's just the truth, and that's how people communicate.
And it's also not how the Supreme Court has read it.
We'll see. I agree with you that this is
what words mean. What words mean.
Well, didn't I say that this is?
He says. Did you watch Dr. Simi?
Dr. Simi?
Yeah, Dr. Simi was the guy who testified in the hearing. I know you need to go, so I'm going to let you go. But Dr. Simi at the hearing, basically, he testified about Trump.
Oh yeah.
He's like, if Trump says to engage in violence, they know he means it literally. If he says don't engage in violence, they know he means do the opposite.
He can't win, right?
if he says go home, he actually means tear down the building.
That's not my position. I don't know if that's Dr. Sami's whatever his position
that's
is.
That's essentially what
we'll see.
Saying.
We'll see.
He was asked. You missed the hearing. I'll tell you this. He was asked one of the first questions on cross-examination. How many people did you talk to who engaged in who went into the Capitol on January 6th?
Like 4. 0. Oh, didn't talk to anyone
who actually was
defendant?
An insurrectionist.
Oh, but like, how could he without it being the legally, like, potentially
he could have
problematic thing? I guess. Whatever.
Anyway, you got to go.
I have to go.
Coming in here.
Thank you so much for having me.
Even though I think that you're kind of just ridiculous in a lot of your takes on this. I appreciate the fact that we're able to have this respectful dialogue.
100%.
And I have more of these.
I appreciate so much your audience and your. I know that you guys are often frustrated by things I say in my positions. I promise you, I'm saying them because they're at my actual positions. But I'm eager to hear your responses, what you think about it, and yeah, I appreciate your indulgence and
we'll finish
and the opportunity. Yeah,
right?
Thanks. Yeah, sounds good. Thanks a lot, Joe, and thanks everybody.
Take care. All right, let me get to some of these super chats over here. I think he's crazy. Okay, I think he's crazy, but I think he believes what he's saying. I think he believes what he's saying, and I think that at a certain point, like he doesn't. When I was saying earlier, and I gave that whole story about the whole litigation thing, the reason I was sharing that is to basically share with you that you don't even realize it. You don't even realize when you're immune to the smell of your own farts. Like and that's what happens when you're in litigation. You're just sort of like, no, this argument makes the most sense. Even where if you walked at it and you were sitting like from on high, you'd be like, are you kidding me? It makes absolutely no sense at all. And we're all susceptible to it. It's not something that's unique to Pisco or I'm susceptible to it also. Every one of us is susceptible to it. You just start believing your own stuff without actually doing a self-assessment, especially when you have layers of issues that all need to stack up and that any one of them would send a house of cards tumbling. It's almost inevitable that at least one of them is really just glass, or not even glass, like just like a hologram. What's the latest? 200 plus feds in the crowd? I don't know. There's a lot. Also, he wasn't convicted. Law did do its thing. President Trump, we covered this. I think was chief executive on January 6th. Thus, you explaining why you said President Trump. Thus, the federal LEOs were undermining the elected chief executive. Name a J6 protester convicted of insurrection. There weren't any. I would believe very little of his argument. Congress ratifies the presidential election, and in a dispute, they vote on the president. He's wrong. I think he would say, I don't think he argues with that. The insurrectionist party to the Civil War was the Dems. Therefore, the Democratic Party should be disqualified from all federal. I don't think that means that anyone who's born after the Civil War, that you know better than that. Most of the Texans claim Texas first, then USA. There you go, Texas. Small states will get screwed by popular vote. Oh, for sure. They'll just be meaningless. The United States of California, if we have that national compact, God forbid. Philip Congers says the popular vote compact would die as soon as California would have to give its votes to a Republican. Yeah, imagine that. Can you imagine that? That'd be hilarious. Does he have any policy interpretations or changes that favor Republicans in a meaningful way? Anything? Vince says to get rid of the Electoral College would require a constitutional amendment. I hope. Well, that's a way of circumventing it. That's the point. The point to the National Compact is, as he was pointing out, that states ultimately ratify and decide who the electors are. So if they say that that our electors are going to be determined based on popular vote across the country, and that's where, and whoever gets the most votes across the country is going to get our state's electors. So that would be purportedly, that would be comporting with the Constitution. I'll tell you this much. Do I think that it's legally sound? Probably is. They would probably struggle to knock it off. God forbid, if they haven't got enough states yet to reach it. I think they're at like 200. Like they got California, they got the expected, the usual suspects of Democratic states to sign off on the whole national compact thing. But basically, each state would individually agree that, assuming we get, and it's supposed to go into effect once there's more than 270 electoral votes available. So that'd be a very, very black day for America if that ever happens. This idea is what California is. Most of the states more conservative are run by liberals because of populations. Yep. Any state action striking from the ballot is premature. Congress has the right to remove the disability, so removing is premature and illegal. I agree with you on that also. I don't think that's going to become... I think this is going to... I'm telling you right now, I'm very confident this is going to be knocked off. And I think there's going to be at least one of the liberal three who are going to sign off. POTUS is national office of the 50 states. That's true. So he agrees with Trump argument, send it back to the states. I don't remember when this came up. Dennis says, typical something is good for masses because it works for me. The minute it doesn't, much like the Supreme Court judges' nominations rule change, they lost their mind when it didn't go their way. That's true. Was Trump convicted? Was Trump convicted? All further rulings to remove him from the ballot are invalid. Even if he was convicted, it should be a long road to disenfranchise voters and their will. It should be impossible to disenfranchise voters. This is like the party which is always afraid of like suppressing the vote. And this is what they're doing. It's called Article 3, Section 5, insurrection law. Officer equals 3 times in Constitution. Go there. Officer of the United States. Trial Charles I all over again. Zachary Keith Hasbrook says, funny how cordial Pisco and Joe are when they probably disagree on most things politically. When Pisco and Stephen argue, it's blood on the dance floor. Well, I think seeing each other face to face makes it more like, a little easier. Constitution is a restraint on democracy by design. That's correct. I think he agrees with you. By his logic, Colorado could prevent an African American or a Catholic from being elected by them. That's true. I think he would. I think that might be. So you're saying discriminate based on race or creed? That could be a different constitutional issue. I mean, it's inconsistent with the other parts of the Constitution, which prohibit discrimination. So I don't know if I think he would refute that and say, no, you can't do something that's going to violate the Constitution. So But this guy has no criticism of local officials actually did change election law in a way that was administered locally without authority of law. I'm not sure which circumstance you're talking about for that, Ed, when you say the local officials did change election law. Dr. Hired says 14-3 first half can't be president or vice president. Second half, president, vice president don't appear, so Congress can never remove their disability either. So that's the whole argument about officer and officer of the United States, which we spent like over an hour talking about. So Trump couldn't ask to create a law, but Democrats could change laws. You probably mean change laws. Trump couldn't ask to create a law, but Democrats could change laws. Which laws are you referring to? I think the point is that as an executive, he can't ask to create a law or ask them to break the law. I think that's what he would say back to that. Age and location of birth, has birth certificate to confirm it. They sued over Obama. Birth certificate proved it. No, it didn't. Don't get me started. Don't get me started. Don't get me started on the whole birther issue. Don't get me started on it. Don't get me started on it. But okay, you got me started on it. No, I'm not going to do it. The due process to check my age and birthplace is to check a copy of certified birth certificate. The due, if I broke the law, is a trial. Yeah. How can you sign into a general sense? You can. I'm not sure what you're referring to there. The National Compact. Are you talking English court official? Nice wig. Lost in law. How are you, Tim? Thanks for coming into the Hornet's Nest. Respect. Yeah, I appreciate him coming in here. Life of Brian says the 14th Amendment consistently limits state power in favor of individual rights. Imagine saying the 14th Amendment allows states to ban minorities from running. So that's, I think, what he would say is that under the 14th Amendment, which bans discrimination, that's what stops people from being able to do that. So Bebop says this guy is literally a dip. I don't know. It just is. I believe it is. That's why. Imagine living life like this. No wonder we are where we are. Well, every time he said that, I consider it a win. I didn't go ding. That's what I should have done. I should have gone like a little. Just that afterwards, I can count up how many of these. Some of the bigger ones I could have been like. What are Pisco's bona fides to even argue constitutional law? He's a lawyer. So we have to follow what Constitution says. It doesn't say that any state can determine for itself that, in its opinion, a committed insurrection is ineligible for office. It doesn't. But he argues that his point on that, which we touched on a few times, but I don't know if he actually expressed on this show, but his point on that is this: that he says that just because it says that Congress can determine it doesn't mean that it's exclusively Congress's domain, and that much of the 14th Amendment is interpreted by states, and they decide these things. I was arguing with him and yelling at him that he's crazy when he starts pretending that was the intent, that's primal, that's going to be primacy, whereas I don't believe it makes any sense to say that they had any power. This is what I opened my argument with him on Saturday night, where I was like, how the hell do you come up here and start saying that a state has a power to decide this when the entire point to the 14th Amendment and all these amendments was to strip them of this power, to stop them from sending someone, that all of a sudden now they're going to be ones to decide where it applies and where it doesn't apply? That makes zero sense. Life of Brian says, how does Pisco reading prevent random judges from doing what Colorado did, declare imaginary insurrections and invoke the 14th? No. Any oath words of the oath do not matter. An oath that's to support the Constitution. To me, I look at that terminology as being really just the broadest possible term they can come up with, to make it as applicable as possible in case people swore a mildly different oath. If they changed one word, would you all of a sudden say that now it doesn't apply to that person? It doesn't make sense to me logically. I disagree with Pisco many of his arguments, but I do like how he engages in insurrection debate. Okay. Commander-in-chief is not a rank. It's a part of civilian authority over the military, not an officer military-wise. Oh, so you disagree with me. All right. I respectfully disagree with you on that. I think it is an officer military-wise. Congress reinforced Section 3 when impeached, tried, and acquitted Trump for inciting insurrection. The issue is closed. States have no authority to address this issue. I plan on talking about it with him next time I have him on. The fact that he was acquitted. And also the fact that the whole impeachment clause basically comes up there and says that you can't. That's in general. That's all these different crimes. That you can't be hit with a crime. He would say he's not being hit with a crime. This is what's so weird. Is like on the one hand, he says it's not losing a power. On the other hand, he says that they have the power that they can take away whatever they want. It's like whichever way he can slice it, he needs to slice it in order to come to this conclusion, even if arguments seem inconsistent with each other. That's when I'm saying, that's when you know you're not able to smell your own farts. That's like, in this context, it makes sense to read it and understand philosophically this way. But in that context, it makes sense to understand it the complete opposite way. And I need to hold both of these in order to come to the final conclusion of he's off the ballot. But it makes sense because in this way, in this circumstance, I can kind of try and distinguish as to, it's like, you go into this whole pretzel logic where you don't realize that you made so many lefts and rights in this maze to get to the outcome that you wanted to get to, that you don't realize that most people are not going to make the same left and same right you are every single time. Or that's the most logical way to go every single time. Ninth Circuit, U.S. v. Waits. Waits was charged with trespass at a post office under state trespass law. Conviction reversed because federal trespass law trumps state law on federal property. Oh, so you're saying so that they shouldn't have the power to interpret a federal amendment? That's what I think. I think it's crazy. I think it's crazy, especially when it's like they have primacy. It's ridiculous. If state courts have ability to enforce federal law, why not for immigration? They stopped Arizona enforcing it in state courts. Yeah, Biden was making the exact opposite argument. He's like, Texas can't decide what they're doing with immigration. Why not? Why not? Why can't they put up their barbed wire? My bad. Someone was charged with insurrection. Trump was charged by the House. And he was acquitted of the charge in the Senate. States have no stand to determine otherwise. It's a great point. He reminds me of an attorney whose office I manage. I'm blissfully ignorant when it's convenient. Yeah. But I don't think he's doing intentionally. That's the point. That's why I'm okay engaging him, because I think he really believes what he's saying. Pisco's entire stance was destroyed by Chief Justice Chase long before Pisco was born. He's a child playing with systems he doesn't understand. Oh, I know. He doesn't like the Griffin decision at all. He can't handle the Griffin. You can't handle the Griffin decision. Allegan News says we all don't mind smelling our own farts left and short. Off topic, can Cedar Rose tell Nick to stop drinking so much again? It's not my business. What of federal preemption via 18 U.S.C. 2383? So he would say you don't need to be hit with a criminal charge, which I think is insane. That's part of what I think is like not being able to smell your own farts. It doesn't make any sense that we're going to say that in one case that they can have an individual judge can decide. Another state's going to say, no, you have to have a jury of peers. Like, none of this makes any sense. And when we're trying to figure out how to interpret a statute, we're supposed to interpret it, an amendment, we're supposed to interpret in a way that makes sense. I apologize to my diggers. I didn't really peek in there very much tonight. Read Jay Sekulo's filing SCOTUS for Colorado GOP. Was Jay Sekulow? I was going through some of the arguments that he put in there. I thought it was pretty well written. Let me make sure this is good. I think I'm good over here on Rumble. Oh, look, I got up to 85 likes on Rumble. One day I'm going to come in here and I'm going to click it. I'm going to click thumb up and there's going to be triple digits. One day it's going to happen. One day. I can't wait for that day. One day it will happen, though. Fan says we all don't mind smelling our own farts. Yeah, you know what? That's probably true, but everyone else does. And you just assume that they don't smell. That's the point. That's the point. All right. Where is it? Is it over here? Is this Jay Sekulow? Yeah. That's what I was pulling up over here when I was sharing the arguments. So I think he did a really good job. He did a really good job. I like Sekulow. I think he's a good lawyer. All right. I'm going to be winding down my plane now. I will be back here. I'm hoping to be here Saturday night. I may not be here. I'm hoping to be here Saturday night, but I may not be here because I have some sort of function party thing happening. So may not be here, but hoping to be here. Anyway, that's my show. I'm sticking to it. I hope you enjoyed. I thought it was an interesting discussion, debate, whatever. And yeah, I do plan on bringing him back here to get into the whole insurrection element of it. So I'm going to be landing my plane right now. It's 12:55. I'm a little bit late here, but I'm still going to try and send you over to my good friend Nick Ricada. That's what we're going to do. So I hope you all have a phenomenal weekend. And the one thing I should tell you is that don't just think that you should walk around miserable or stuff like that. That's the worst way to live life. You always want to make sure that no matter what happens, you're going to be happy, stay happy, and make sure that you want to stay happy. Eat some bugs. Eat some bugs. Eat them. Eat them. Eat them. Eat them. Have a great weekend. Godspeed. Oh. You want to be here New Year's, Sunday night. Make sure you're here. New Year's, 6-hour show. It's going to be great. A lot of guests. It's going to be great. Don't miss it. Sunday night. Till then, Godspeed. That's not the right thing. We didn't shut down. I know I didn't shut down. No, I did. All right.